mention item.
Item number 47, Your Lordship. So dated 28, Your Lordship.
Scan copy noted received. Kindly put on the microphone.
On your
47 supply list.
Yes.
Scan copy noted received. Scan copy, scan TCR noted received. After how many days you prefer? After
1 week, Your Lordship.
after 10 days, about 10 days,
10 days.
approximately 10 days.
Date may be fixed, Your Lordship.
Let it be on 1/9.
Oblige, Your Lordship.
1/9.
Wait, please, Your Lordship. Lordship, I beg to mention item number 42, Your Lordship.
42.
The consent of the other side has already been obtained, Your Lordship. There is certain personal difficulty on account of Mr. PJ Sekia, Your Lordship. And praying short accommodation.
For today? For today?
For today, Your Lordship, I pray that the matter may be fixed, Your Lordship, in the month of
Fixed.
September on 25th. If not,
Criminal revision. Hearing matter. Okay. 5th of September you want?
25th.
25th of September.
Or maybe 5th, Your Lordship.
No, it's a 22 matter, can be fixed. Learned Council seeks an adjournment for the day. As the leading counsel is having some personal difficulty to conduct the hearing today. Fixed on 25/9.
Keep you.
May I please vote, Lordship? I will move to item number 31, Lordship. In this item, CD is not available.
31.
31. Can you fix a short date?
Interim bail is there?
Interim not there.
Okay. CD is not received. Okay.
In this case.
31.
Okay.
31, right? 31.
31.
Item.
Item number 31.
Still not received. CD. Is lying on the Honorable Court of Law website.
Oh,
What is the court?
in the district court. Okay. So it can be procured from there. 31. Case diary noted received.
Okay.
Issue reminder. Fix on. Let it be not very long since you are not on interim, right? So I'll fix it on. When do you want it?
Any short date, Lordship, as you.
20th August. 29? 29/8. Yes.
Your Lordship, item number 29. In case counsel for the petitioner is out of station, kindly fix the matter after 26th August.
We have received that case then.
Case diary. Interim is there? Interim is there?
No interim is there.
No interim is there. Not sure. Yeah. 6 adjournment. As the leading counsel is outstation. Full stop. Prayer is allowed. Case diary received, be retained. Fixed on.
Can retain.
Yeah, it can be retained. You are seeking on 26th.
26, after 26.
After
August.
26. 29. 29/8.
Wait, Your Lordship, I beg to mention for listing, Lordship. As per roster, Lordship, Lordship is the competent court to pass the order for listing, Lordship, because that is why. Because approaching senior, again redirects to the, as
In
per
the-
roster.
In the order of seniority, I was told, senior most, if not available, next one, and then like that. Right?
But it goes as
So-
per roster, Lordship, that is why even.
So
yesterday also some. but-
yesterday also.
Lordship, for tomorrow, praying for tomorrow.
No,
service.
I have no problem accommodating, but as I said yesterday also, we
Yes.
just have to follow the practice direction.
Yes,
I would just humbly suggest to you that you make a mention in the next senior at 2 o'clock. If it is not allowed, then you come here.
Yes,
Right?
and then I'll make a mention at
Yeah, yeah.
2 PM again.
Yeah, you
Keep them.
you make a mention
There.
there at 2, because now it will be over.
Yes.
And then
We'll come
if
back
it
here.
doesn't work here, then
I'll
then you
come
come here.
Develop.
Yeah, please, Your Lordship. Lordship, my senior is currently out of station for medical treatment, Lordship. Kindly adjourn for today, Lordship.
Which one? Which matter?
Item 22, Lordship.
22.
Yes, Lordship.
Lordship, kindly matter may be fixed on next week, Lordship.
Next week?
Next.
Okay. Learned counsel, your good name, please?
P. Bodo, Lordship.
Bodo.
Bodo.
P. Board Land Council, seeks an adjournment as the leading senior and guest counsel is outstation for medical purpose. Prayer allowed. Case diary received. Case diary received shall be retained. Next week, any preferred date? Next week?
Any
29? Okay, 29/8. Yes, can
May I please, your lordship, I beg to mention an urgent listing of IA number 805825. And bail application has already been listed in item number 30. So in pursuance with this case, they filed an IA.
IA. Okay, it had come up yesterday also, this matter. Okay, I think IA we can take on record, I think. Yeah, please do file. No more mention.
At least, PA item number 1.
May I please, Lordship? Lordship,
Tell me.
attempt to murder is there, Lordship. I'm praying for a short date.
Case diary.
Diary.
Okay.
Horlumuk police station only, Lord.
Let's try and get the medical report also.
Lordship.
Your good name, sir?
S.H. Ram.
S.H. Roma. Learned counsel fairly submits that at this stage, case diary may be called for. Of Bharlumukh PS case number 118 of 2025. Under so and so section. Medical report, if available, shall also be procured. Accused is in custody since 31/7,
Lordship.
2025. Fixed on any preferred date, any suggested date you have?
28, Lordship.
28, let us fix it on a motion day. That will be better.
And 29.
29th or 1st?
First.
1st September.
Okay.
Item number 2.
May I please, Lordship? But another connected bail application by the co-accused has already been fixed on 1st of September.
Okay.
So I am praying, Lordship, this matter may come up along with BA number 265025.
Okay. If it's not late for you, no issues from my side.
9/25.
Hmm.
2650.
M. Khan Learned Counsel submits that connected, not connected, out of the same FIR.
Same FIR, co-accused.
The bail application of co-accused being BA number
2650.
is fixed for case diary on 1st September and prays that this petition may also be fixed accordingly.
Well, CD may also call for it, this case also.
In
In
this
this case.
Yeah, I will call. In that case, CD has been
CD
called.
call.
Same CD, but
Same,
we'll
but
call.
Otherwise, on that day, it will come in motion, Lordship. That's
No.
why CD will be required.
Yeah. Call for the case diary of. Both of them will be in bail hearing then.
My lord.
Right. Jogi Ghopa PS case number 91 of 2025. Consult police
My
station.
friend is saying that item number 5 is same.
Same order Lordship may pass, in item number 5.
5 also.
But same order. Along with bail application number 2650.
That which you mentioned.
Same.
You mentioned. Fix on 19 along with BA number so and so and I go to and this one. Mr. Abdullah, can your number please mention.
2650, same bail application.
Oh, same bail application.
Same bail application number, my learned friend has submitted, my lord. That is, my item is item number 5.
Okay.
Along with bail application of 2650 on 1st of September.
1st of September. Item number 5, A2 of 27122.
Oblige, my lord.
Number 3.
Yeah, please, Lordship, the 483 application in connection with Fulton Bazar PS case number 296/2009. The Lordship will find the FIR case number 11. This is a long pending case, Lordship. The FIR was lodged on 5/6/2009. Yes, Your Lordship. Now they have started investigation.
No, anyway. Happens. Should we read it? You can read it.
Yes, Your Lordship. With due respect, I beg to inform you, Your Honor, that the deceased late Utpal Banika is my younger brother who was running pretty business at BK Kakoti Road near so-and-so, Guwahati so-and-so under Polton Bazar PS. The parents of the Utpal Banika, permanent resident in village Sorbuk in the district of Borpeta, and his wife was also in the said village at the time of occurrence of the incident, and we were also in Borpeta at that time. It is reliably learned from the eyewitnesses that on 29/5/2009, the accused person below them attacked my brother and attempted to murder him, but somehow his life was saved. But he sustained grievous injury, and subsequently on the very next day, that is on 30/5/2009, my brother Utpal Banika expired at CMC's Bhangagar, Guwahati as a result of that attack. As already stated, most of the family members of late Utpal Banika reside in Sarbuk, and therefore no family members could lodge FIR in time, as they were engaged in performing ritual of the deceased, and therefore none could come down to Guwahati to lodge FIR, and hence this is the reason of delay in filing FIR. Hope your honor would be pleased to register a case against the accused person under the appropriate section of IPC, and be pleased to book the culprit, for which we shall be grateful. Now, Lordship, this is the FIR. After lost the FIR on 5/6/2009, Lordship, the police has not done anything, Lordship. In fact, the petitioner is also residing only within the 2 kilometer distance from the police station, Lordship. There was no such specific allegation that, Lordship, the informant has seen the occurrence, Lordship, that his brother has been murdered by the present petitioner, Lordship. There was no such evidence found by the police at the time when the incident was investigated after lost this FIR, Lordship. And he has been arrested by the police only on, Lordship. Your Lordship will find at page number 17, accused forwarding report. Here also, Lordship, in the ground and reason of arrest, Lordship, there was no mention that he is prima facie or directly involved in this incident, or his statement was either it was recorded or any notice has been served upon him to appear before the police station earlier, Lordship. There was no such ground.
Right.
Okay, is going to be called for.
And you can also take, I'll just mention, we not call for a report, but you take instructions regarding this elapse of time. Very peculiar, isn't it? 16 years.
Yes.
16 years, what happened? Final, no investigation, nothing. Your good name, please.
Deva Sharma.
D. Sarma, learned counsel for the accused Bijoy Kumar Singh, alias Bijoy Singh, who was arrested on 19/6/2025 in connection with Paltan Bazar PS case number 296 of 2009 under 30234 IPC. One peculiar aspect noted is that the Azahar is dated 5/6/2009 itself, 2009, and in which 8 accused persons are named. Where is his name? His
Lordship Bijoy.
okay. Named including the present accused. Call for the case diary from the concerned police station. However, the learned prosecution shall also take instructions from the IO as to what happened during the intervening time of as much as 16 years since the registration of the case, since the lodging of the Azahar and the registration of the case. Fixed on 19 or 39? 39. Highly obliged.
Number 4.
May I please, Lordship? My lord, the case
8/7, right?
8/7 was arrested,
Mhm.
and FIR, my lord, page 8. Allegation, my lord, against accused number 1. 6 number of accused already been named,
Mhm.
but so far the version of the FIR, it's appear the entire allegation against accused number 1. However, kindly have a look, my lordship. May I read, my lord? most respectfully, I beg to state that 1 week before, in between my husband, Abdul Salam, and the accused number one, namely Abu Bakr, a dispute took place regarding a fishing net, and therefore to settle the matter, one meeting was held on 4/6/2025 at night, approximately 8:30 p.m. at the residence of Kamaruddin. But the meeting and altercation gave rise, in between which resulted an incident happened in between the parties, and my husband was beaten up severely by accused number one, attacked and injured with a knife on the head and testes, causing several injuries. After incident, my husband was brought to Barhigram Govt Hospital for treatment, but doctor referred my husband to the Karimganj Civil Hospital, and thereafter forwarded SMCS, wherein my husband is in serious condition. That it is suspected that a pre-planned manner they attempted to kill my husband, hence in accordance with law. So far, attempt to murder is suspected, and previous hurt and injury, my lord, so far allegation is against accused number one. Now, my lord, accused number 4 and 6, before lordship, they were arrested, and they are behind 43 days behind the bar.
Abu Tahir and Abu Azma.
Abu Azma. My lord, so far length of detention is concerned, and so far allegation against the accused number one, my lord, at this moment, my lord, on the basis of the length of detention, they may be released, my lord, 43 days behind the bars. Against Abu Tahir and Abu Azmal, there is no specific allegation.
No specific allegation.
You will be separating whether.
But it's 43 days, my lord. 43 days, there no allegation is there. If the entire affair, the face value accepted, even though there is no allegation against the accused number 4 and 6.
Some vicarious liability is attributed that in a pre-planned manner, but you're right. Specific allegation is only against one.
One.
So at the moment, only this much we have.
Yes. So
Short date.
Because my lord, so far 43 days behind the bar.
I understand.
Lordship. So consider the constitutional finding. Their relative,
You are Mr. Talud.
A. Bhuyal.
A. Bhuyal, learned counsel, who was taken the court to the Azahar, dated, what is the date of the Azahar?
Actually,
6/6/2025. Containing that the present, there is no specific allegations against the present two accused persons. The allegations, however, are about assault and causing grievous injuries. Call for the case diary along with medical report, fix on, get a short date, 2027.
27.
Which is the police station?
My lord, this is
Tribhumi,
Athar
Karimganj.
Karimganj. So 29th will be safer, but we can take a chance on 27 if you want. 29 will do, no problem. Can you manage? 29.
Obliged.
Item number 6.
On the last occasion, my lord, a report was called for from the concerned police station, my lord.
Report was received during inquiry, no evidence and cognizance of the incident of the FIR was found and forged. No case was registered, and the FIR along with the inquiry report has been kept in file.
No case registered.
Okay,
I'll have a look. So as of now, there's no apprehension of arrest.
My lord, only one thing, my lord, whatever my learned friend has submitted, that
I'll record it.
that be kept as a part of the record.
This report.
Yes.
Yeah.
And case may be closed.
If something else happens subsequently, then you have.
Then, my lord.
You always have a remedy. You
Yes.
can come again. But for the moment, does not seem to be any apprehension of arrest.
Well, on the front of the report, my lord, case may be closed.
Raki, just first 4/8 order, first two paragraphs in. On the basis of the said contentions, a report was called for from the concerned police station about registration of any case with regard to him in the said police station. Full stop. Pursuant thereof, the OC Borpeta Police Station has submitted a report.
Borpeta Road, man.
Oh, yes. Borpeta Road Police Station has submitted. Here it is written Borpeta Police Station. So I mention like that. In the report, it is stated that an inquiry was conducted with regard to some allegations over domestic issues. And it was found that no case has been registered and no FIR against the accused kept in the file. And that the matter has also been informed to the complainant. This report may be kept with the case file, and in the context of the aforesaid nature of the report, there's no basis for apprehension of any apprehension of arrest on the part of the petitioner, and accordingly, the instant petition is disposed of on the aforesaid line, on the said lines.
Seven.
There was the same period of no cases has been registered against this petitioner. I report dated 28/25.
Report.
There is no FIR also.
Okay.
Without any FIR, my lord, he is being harassed, my lord. So he may not be harassed. Date of
During the message, checked the PS available records and found that no any case has been registered against Alaluddin.
Report has been received? No, this is the first time.
No, report has been received as a message notice on 28/25. Reported by as far as checking list received. The message, the PS available records and found that no case has been registered against Alaluddin. So no case that could not be sent. Case is not registered against.
Oh, this is the second date. Sorry, I have not seen this.
Second date. Ali was 12/8/25.
Rakhi, it is earlier part to the first 1, 2, 3, last order. Next paragraph. Pursuant thereof, a report dated
28/25.
20,
Not six.
208/2025 has been received from the
Report means not with a message from the
a communication.
communication.
A communication dated BSAT 2/28 has been received from the which is the police station, Dalgaon police station, in which it has been stated that no case has been registered against the petitioner, nor any FIR filed against him in the police station as of now. In view of the same, any apprehension of arrest in a non-bailable case is unfounded, and the petition stands disposed of in the aforesaid terms.
He may not be disturbed.
No, there's nothing, there's no basis, but one thing we can say,
Imagine.
this report will be kept in the case record. This communication, so a copy of the communication be kept in the case record. I'll do.
Item number 8.
Please, this is, my lord, it's identical so far item number 4 is concerned. But here, my lord, as evidence, FIR, only allegation against accused number 1. Now, my lord, so far accused number, petition number 2 is concerned here, my lord. He is, my lord, a school teacher, my lord, that page 14. 14, Abdul Rauf, his petition number 2, my lord.
Let us see the Azahar.
Lordship, Azahar, my lord.
I can read it. I can read it myself.
Same Azahar, my lord. Page 8, my lord.
Oh, the connected.
Yes, correct.
Therefore, sir.
And Abu Tahir and Abu Azmal already behind the bar, my lord. And so far, my lord, allegation is concerned. The allegation, my lord, Abu Bakr, against Abu Bakr.
Just a minute.
We have case the fixed date.
This is
item number 4,
I got
29/8.
But I pray, my lord, interim, so far the teacher, because against him no allegation is there.
Let me
Page-
see.
Page, my lord, 14, my lord. He is a teacher, school teacher,
Just
my lord. And
Yeah, I got it.
petitioner number, my lord, 4, my lord. Abu Sufyan, aged about 18 years, he is student, my lord. And my lord, at this moment, my lord, I pray only this petition number 2 and 4, interim protection. Because there is no allegation against them. And so far their profession is concerned, my lord.
The same case is fixed for 29 lordship.
Lordship, in the meantime, my lord, only for this petition number 2 and 4, interim protection will be given. 2 is a teacher, my lord, and 4 is a student, my lord.
But there's general allegations is against all of them actually.
No, only allegation against.
No specific allegation, but
Against.
in a pre-planned manner.
Pre-planned man.
The
Suspected, my lord.
at the moment we have to go by the Azahar. Right?
Allegations is clear.
Allegation, my lord, entire allegation against accused number 1 and letter last 2 sentence, it is suspected.
You wanted to show me one document regarding his teacher, you said?
Teachers, my lord, page 14, my lord.
Madrasa.
Page 14,
Abdul Rauf.
this is ID card, my lord, issued by Department of Secondary Education. He is a teacher of JMU Senior Madrasa.
Anyway, at this stage, let us call for the case diary. Let us see the diary and medical report. Call for the case diary along with medical report. And which is the date which fixed?
29/8.
29/8, along with. So
Medical report.
should we mention the case number of the other one? It will come automatically
Yes, yes.
along with medical report.
Lordship, petition number 2 and 4, my lord, protection will be given.
Protection at this stage, not inclined to give interim.
Item number 9,
Lordship, kindly timing for the matter. I engage for the matter.
number 10, my page, Lordship. Lordship, this is a PRS bail application, my lord. Page 9 is the FI.
Page 9,
Page 9. And select profile.
let us read it.
Respectfully beg to state that my younger sister, namely so-and-so, is about 16 years, is a student of class 10, studied in BG Colony High School. On 30/10/24 morning at around 9:30 AM, my sister went to the school. But I'm
Fixed on
10/9.
longer than 10/9. 10,
9/9.
10/9, 10/9.
And number 12,
My lord, the petitioner is a my lord, teacher, my lord. And
Okay.
case relating to my lord, SX method is a online application. And the matter went to my lord Supreme Court, my lord. The Supreme Court has granted some other accused, other granted bail. And this honorable court also.
Co-accused have gone to the apex court?
I'm not a member.
No, the co-accused.
Co-accused are there. And apex has already granted bail. And on the basis of the apex court judgment, my lord, this court has already granted bail to some other accused.
Right.
Page, my lord. 43 is the this order passed by this honorable court, madam. This page 43, madam. 11 position, madam, page 4, last position, madam. Paragraph 6, madam.
Just a minute. 43.
Page 44, last, paragraph 6, madam.
Let us see the Azahar because I'm I am new to this case.
Madam,
So
page 14, madam.
let us see that.
Page 14, madam. Right. This one is also a victim, madam. He is a victim.
Is Rupam Sarkar.
Page 39 onwards, madam.
He also supposedly invested
Invested.
and, because he's apprehending arrest.
Madam. He is also a victim, madam.
In
Page 39 onwards, madam, is the order passed by the Supreme Court, madam.
any of the named FIR named accused granted bail by Honorable Apex Court? No, but by our High Court?
Madam.
No. No, other people.
Madam, only 2 persons are named in this. Madam.
Okay. No.
I am also not named in this.
No, you are not named. Abdul Hai.
No.
Ashraful Ahmed, Anwar Hussain, Deepak Paul.
Abdul Hai, madam, he was arrested, madam. He was granted bail by the Honorable Court.
Ashraful Anwar, Deepak Paul.
Madam, Abdul Hai, madam.
These are the named.
He was arrested, madam. Abdul Hai.
He was granted bail.
Granted. And it is page, madam, 25.
Anyway, so
I think it's an organized crime, lordship, sometimes. I mean, many people are suffered in this type of.
true. What is your summation on the prayer for?
Involvement of the petitioner. Whether the involved, what is the role of the involvement of the petitioner, lordship? It can be revealed from the case only. That's why
That is true. He is not named, no doubt.
not named. lordship.
Okay, let him record the statement. That will be fair. Your good name? Sir?
Ekhoni, madam.
Yeah, sorry. Ek Honekar, learned counsel for the petitioner Rupam Sarkar. Rupam Sarkar.
Rupam Sarkar. Rupam Kumar Sarkar.
Rupam Kumar Sarkar filed a bail application under 482 BNSS seeking pre-arrest bail in connection with Abhayapuri PS case number 216 of 24 on the so-and-so site, banning of deposit. The Azahar dated 6/9/2024 names 4 persons who were stated to be leading the activities of misappropriation of crores of rupees through illegal apps named headaches. Full stop. It is submitted that co-accused. No, he is not an accused, because he is not named.
Similarly situated.
You said Abdul Hai was granted bail.
Abdul Hai.
One or more of the named accused have been earlier granted bail by coordinate bench of this court. The learned counsel seeks interim protection. The learned additional public prosecutor DP Goswami submits that these alleged offences are in the nature of organized crime, and the role, if any, of the present petitioner can be ascertained only after perusal of the case diary. I find some force in the said contentions. Call for the case diary. However, since the petitioner is not named in the Azahar, nor any specific allegation made against him, therefore, at this stage, he can be given an opportunity to join the investigation and get his statement recorded. Therefore, in the interim, 25,000 one security. Cooperate with the investigation. Appear before the IO within a short time. I'm not giving any time frame, but as early as possible, within a short time, and make himself available for examination, semicolon. He shall not hamper or tamper with evidence. Right? We'll fix again on 10-9. 10-9.
Diplo.
Lordship, kindly transfer for the time.
For the timing? Okay, after some time.
14.
May I please, Your Honor? Lordship, petitioner referred Lordship, he's a scientist, my lord. Presently posted at Silsar.
I see.
He's
What
working
happened?
under the, I annexed the copy of his identity card, that is of page 11, my lord.
What happened actually?
What happened in this case, since February onwards, he was on medical leave, my lord. He's a differently able person. That's scientist. And since February onwards, he was on medical leave. Recently, the police person from Lucknow police station, they visited his official quarter twice. And he was not there. He was outside for his treatment. And he is the police person. They have asked the neighbors to send him to the police station for some investigation. Therefore, he sent one advocate along with a friend to inquire about any case being registered against him. But they have not developed anything, disclosed anything. So till now, he is not aware whether any case has been registered or
Oh, I
not.
see.
Even as because the government has also not nominated any designated officer. 45. So they are also not been able to find out anything. Because nowadays the government has nominated one person as a designated officer under the BNSS. So any FIR lost against any person in any police station, that FIR should go to the designated officer immediately within 24 hours.
Is it a case of zero FIR, this one?
We are not aware whether
we
any
are not-
FIR has been
oh.
registered or not. my lord.
Any cases registered or not?
But we can take he can take an instruction
Yes,
from Lakhipur police station.
Yeah, lucky probably. In Kasar district. Till the report comes from, no course measure taken against him.
Actually, I've seen such orders being given sometimes, but it's a very vague thing actually,
Yeah.
without any specific information.
Yes.
Which case? So let us get the report.
Till then, because he's a scientist, he's a head of the department in that particular unit.
Where?
In Silsar, he's working under the Silk Board, under the government of India. Identity card is at page 11.
Because
Central Silk Board.
will it be correct to say that in the event of arrest in any case, and that will be actually there's some guidelines also, I think. Of course.
No cases there.
But I've seen some orders on those lines been made. But anyway, there's a judgment of our High Court, I think, on this point for guidance. Let's see. Anyway, so if you can hold on for a few days, we'll get take a short date. Lakhipur is Kasar, right?
Yes, my lord.
Let's see. The third Arshekar, learned counsel for petitioner Ninjom Mohendra Singh, who stated to be a scientist working in the Central Silk Board
Central Silk Board, yes, my lord.
and posted at Silchar. Full stop. That, though he is not aware of registration of any case or filing of
In Lakhipur case.
FIR against him at Lakhipur police station. But he has come to know from his neighbors that police are looking for him and have told the neighbors to send him to the police station, thereby causing him apprehension of arrest. Full stop. Third, learned additional DP Goswami. A report may be called for from the whether any case has been registered against,
Yeah, Lakhipur PS.
whether any FIR has been lodged against the petitioner or any case registered at the Lakhipur police station. Regarding the interim, I look for some guidance. Kindly see, this case law, but there is a judgment of High Court specifically on this point.
Even our High Court has also passed.
I've seen, but I mean,
Yes, sorted out the way for.
feel little uncomfortable because vague, yeah, because there's a judgment of Honorable Supreme Court saying that blanket orders of blanket orders prohibiting arrest should not be passed, right? But I have seen such orders,
Yes.
in the High Court. So there is a judgment. I think the guidance comes from there. So if we can locate that, that will be helpful.
Definitely.
So if you want some protection, then
No course of measure may be taken till the report comes.
We have not specific information about regarding the whether case is registered or not. If registered, then given a short date, we'll produce the report only. Let it on 27 or 28, we'll do the report in the media.
get a short date, 27. Because we do not know what section, what allegations, interim protection, any order of interim protection requires those basic things, nature of the allegation, whether his name, But I mean, see, we are all learning continuously that we must locate both those judgments where the Supreme Court has guarded against, cautioned against blanket orders. And also our, there's a reported case. Okay. So for the moment, this case, let's wait till 27th. For future guidance, we should have those.
Limited item 44.
May I please alert? The petitioner, father's name is Dilip Kulita, who is a business person. He has a pharmacy and other medicine business. The petitioner is David Kulita, is a son.
Okay.
He's passing a ITI for plumber, is doing his business as a plumber. He is young man. What happened? The complainant Doljit Singh Sodhi, a son of late Sugodev Singh, FIR contents, residents of the Dotinagar PS Lotus Ambari, District Kamrul Metro Assam, had lodged an FIR on 0207 before the official in charge of Gosur Police Station, alleging inter alia that on the last day, 17/06/2025, he was a tire shop adverse who situated at Lokra Bamunpara. He know the customer Narayan Das. Residents of the North Goa Gopi Tires at the time of the purchasing the informed them handed over a check bearing check number 8 lakh rupees 4,000
And cash.
in cash. And the check was by shop name was not mentioned. Wherein and his money payment completed and taken away the tire, but it is a matter of unfortunate. His shop employee, see David Kolita, he is not employed, he is a plumber. He is not employed. Son of the Dilip Kolita, a resident of Hazo, he is not a resident of Hazo, he is a permanent resident of Guwahati, Guwahati near Hattino. Resident of Kamruk Metro, and this check was stolen from my shop, and his name was entered in the said check, and his account number so and so of the State Bank of India Hattigao branch, and thereafter transfer the said check at present. The petitioner switched off his mobile, so he requested sir to take necessary action. The phone number so and so and his father phone number. On being the receipt, the affair Gosur Police Station registered a case being number case number 240 under section 306 316 B4 318 of BNS 2023 and started investigation. Whatever it is an entirely false FIR. After the 13 days, cause of action 13 days, FIR is lodged before the PS. He is not employed. He is a plumber. Whatever money is the payable of how it is payable. His father is a businessman doing his medicine, and he is a pharmacy in different debt 25/7 for an amount of rupees for 4,50,000 taken a loan. After 11 for an amount of rupees 1 lakh and 18,325 amount rupees 3 lakhs. Total amount rupees 8,50,000, and in his business purpose, he as a plumber 15,000. He is payable amount to him the accused person. Now it is an entirely false case. What happened actually at the time of the drawing of the amount? Given the consent, and his one of the employer taken accompanied him to deposit the check, and the bank manager telephoned to him. He given the consent. There is a sufficient proof at the bank. But it is not stolen, it is the payable amount. And now police is giving the harassment to his family members and giving a false FIR.
But to learn it trial court, after praise of the case.
I've
there-
seen.
Yes, but
I've seen.
the check was encased by the petitioner,
Mhm.
that is petitioner.
If they, because if there's some monetary transaction or something, because it is not, no documents are there, which is reflected in that order. That's what I was saying. That's all. So I think it may not be a suitable case for interim, but
No, your lordship,
call for the case diary.
no, your lordship. I am giving an opportunity to investigate a matter, giving an opportunity, like a good person, to interim relief. Otherwise, I shall be victimized. Your lordship, I am just giving a peaceful decision.
At the moment, we have to go by the allegations in Azahar. So you can definitely help me with any materials to indicate that this was actually, some dues were to him, and the
No.
check was issued in his favor for those dues.
Your lordship, my respectfully submit, the bank manager given the complaint and given the consent at the depositing the session. There is a sufficient proof in the bank. All for the bank official report also.
This is
My respect to someone given an opportunity.
different compass, actually. These are serious matters. The amount is also very high and not, obvious, high by the standards of ordinary people in the country, 8 lakhs.
Amount is high.
Not about the due payable amount.
482, just a minute, sir.
No, sir, good guy.
It's okay, we will have. We'll get a short date, don't worry. Then we'll see. 482 bail application. For the petitioner David Kolita. In connection with Gorsuk PS case number 214 of 25 under section so and so. Heard learned. Your good name, sir?
M. Talukdar.
M. Talukdar, who has taken me through the Azahar. The gist of the allegations in the Azahar dated 2/7/2025 is that on 17/6/2025, there was a monetary transaction. The gist of the allegation lodged by the informant having a tire shop is that one of his customer had issued a check of 8 lakhs 4,500, but name of the shop was not mentioned therein, and that the present accused petitioner, who's working in another shop, in his shop, stole the check and deposited the same in his account number so and so. The learned counsel has fairly annexed the copy of the order of rejection of anticipatory bail by the learned court bill. It is stated therein that that the encashment of the check by the petitioner has been revealed from the materials, and there are also no documents to show that the amount was receivable by the petitioner. Nevertheless, call for the case that the learned counsel seeks interim protection. A call for the case diary from the concerned police station. The prayer for interim bail stands rejected at this stage, as the petitioner is named in the Azahar and direct allegations are against it. Call for the case diary, fix on, get a short date. 29?
8 days.
28, sorry, not 28. 27, short, 27, 27, 27, Wednesday. 1 week. You can take back this, you can take this decision. You may need it later. Something was, just a minute. Hang on, sorry. Just a minute. Supply, okay. Supply get hold. Hold on, Arun. It is on. Okay. Admission of person. Bail hearing.
Daily bail hearing item number 16.
Yeah.
Not should be passable matter for the time being,
After some time?
after some time.
Maybe taken it through, my lord, because my lord, there is the PCR is available, my lord. I need to go through it, my lord. Arms Act provisions are also there, my lord.
Voluminous.
Yes, ma'am. So then two, my lord.
Second half.
Did
17.
May I please, your lordship? This is second bail application, your lordship,
Mhm.
and
Item number 16, my lord. Item number, last item, my lord, lordship has picked the connected matter, my lord, on Tuesday, my lord. Yesterday, my lord, one matter came up, my lord.
Mhm.
My lord, we have, my lord, cited one decision of the Honorable Apex Court, my lord, recent decision. Because they
Oh,
are,
yesterday,
yesterday, my lord.
yesterday.
So this is also arising out of the same police station case, my lord.
Okay.
There are 8 equals, my lord.
Mhm.
She is also one of them, my lord.
Mhm.
So, my lord, my lord, this matter also will be maybe taken up on the 27th, my lord.
27.
Lordship has already picked that matter on
Mhm.
27th.
Same FIR.
MFI, my lord, charged case.
Is it okay? Still not.
No, my lord, let
You
them
want-
come, my lord. They are not the counsel, my lord.
Oh, they are not the council.
They fix the matter at 2 PM, my lord.
Which one? The
I earlier was.
oh, the earlier one. So this one. Oh, yeah.
So let them come, my lord.
Oh, at 2 will,
My lord.
after she comes. This is your match.
yes. This frustrated matter, your lordship, earlier it was rejected, and
Learned judge is not available. Who is rejected?
Yes, my lord, here, my lord, is the POXO matter, service is awaited, my lord.
No, no, the earlier rejection order, the learned judge is not available.
yes, yes.
Who had rejected?
Oh.
Justice Pathak, sir?
No. Malakari Nandi.
Oh, she is retired, madam is.
This time, your lordship, my application is regarding on compliance of section 47 and 48. And earlier it was not closed.
He's been in custody since how long?
380 days.
80 days. And you are, do you have, are you up to date with the,
Yes, my
what
lord.
is status of trial? Status of trial? Can you?
3 witnesses have already been examined, including the victim, your lordship.
Okay.
When I have annexed their deposition hearing. And the petitioner, he was arrested on 5/8/2024. And as on date, 380 days. Your lordship.
He was pregnant also. Yeah, you wanted to say something? Vasu?
Yes, my lord, as because my lord, it is a POXO matter, my lord.
Yeah.
Service need to be, my lord.
Service is not complete?
Not complete, my lord. I had,
Oh.
before, few minutes ago also, I have communicated with the jurisdictional, police station, my lord.
Mhm.
Here, my lord, the case is there, my lord, that is it is.
On the next date,
My
we
lord,
can take, and then also we'll go into merits as well as that aspect.
my lord.
48.
Lordship, one, it will be the last chance, your lordship.
No, I cannot write like that because, because
Because the next one will be the fourth.
no, I cannot go against the law laid down with this.
My lord.
If I disagree, I'll have to seek a reference to a larger bench. No, this has to be there.
It will be
Notice,
amount to violation of
notice has to be.
the order of the owner.
You can take multiple, you can take steps by multiple channels, but notice has to be there. Though appearance is not essential.
Notice, your lordship, I'm saying, your lordship.
You can take fresh steps also if you want. Why don't you? You can. If-
Fresh step, your lordship, I think it will.
Because there's a problem of location. There's a problem of
Earlier
location.
occasion, your lordship, the notice was served to the informant, your lordship. But this time, your lordship, I do not understand, your lordship.
At the same address.
Yes, same address. The fact is that and next day will be the fourth time, your lordship. The question is, we are also answerable, your lordship.
True.
Therefore,
But you cannot expect me to,
Very short date, my lord.
violate the
Very
law
short
laid
date,
down
my
by
lord.
this court, right?
Communicate, my lord.
date may be fixed.
Yes, certainly.
Short date, my lord.
You can suggest
Please suggest to, let us know.
29th, 27.
Before date, my lord, 27.
27th.
27.
Publish.
18.
My please, your lordship.
Appeal lordship, we have received the case diary. We have received, FSL report yet to be received also.
Commercial quantity.
Commercial. Total custody is 6 days.
66 days in custody.
36 days.
Wait for the FSL report.
Charge sheet is not yet submitted. CSS.
CD received.
Charge sheet not submitted. Cannot be without.
29.
In commercial quantity, they have a long time, right? Statutory period is 180 days.
90 days. Recovered 298 numbers of Costa Tea syrup, cordon prospect equivalent hydrochloride. Only 36 days of debt loss. So
37 determination is not impossible without FSL report, but it will be more complete if you have the, can you wait till we get the FSL report? It is submitted by learned prosecution that though case diary has been received, the FSL report is awaited. Full stop. The alleged quantity in question being in the bracket of commercial quantity. Determination under section 37 NDPS Act would be necessary for this bail adjudication. Your good name, sir?
A.A.R. Karim.
A.
R. Karim.
Okay,
R. Karim.
I get it. Learned counsel, so. Assisted by your madam, your name also. R. Begum. So we'll wait for some time. CD will be retained.
CD may kindly be retained, your lordship.
No difficulty. CD receipt may be retained. Fix on
5 lordship.
5/9.
Lordship.
Because in considering the FSL, it will take time, lordship.
Yeah, that is the problem actually.
Lordship.
19.
Already 47 days behind the time, no? Allegation is under section 75(2) of DNA in section 12 of POCSO Act.
12. What is 12?
12 sexual harassment, my lord.
We have received.
Then it's not a subsequent in
My lord.
that sense,
We have received the case diary.
We can see the whole issue again.
My lord.
Same as lordship, the FSL report not received here, lordship. As far as the IO note 4825.
Mhm.
Even behind the also from 129 days.
He's a student.
4 months.
He's a student.
Student, my lord. My lord, kindly may peruse that page 25, my lord. He is a regular student of third semester, my lord.
Mhm.
And
Anyway,
any real issue is that, my lord, it is some different than the present allegation, my lord. In this case, my lord may kindly peruse that page 16, my lord. And original copy at page 70. My lord, the present accused, he purchased a second-hand iPhone from one Akhtar Hussain Borbuya. And thereafter, after using this mobile for 4-5 months, it was not working. And in the local area, Borpata, he was not able to solve this problem. So he has to come to Guwahati for mobile specialist. And he submitted this mobile in M repair, page 19, my lord. And page 19. M repair, and this receipt was issued in favor of the present accused, that is Ziaur Rahman. And mobile was received and deposited in the M repair on 26 March 2025, and date of delivery was next day 27 March, but it was not given by the mechanic because some problem was there. So after 15 days, the mechanic was given the date on 11/4. 11/4/2025 date was given, and accordingly the present accused come to the repairing center, and whole days he was waited, but the mechanic instructed that next day mobile will deliver. So at 6 to 6:30 he went to ISBT. He was not got any bus to go to Borpeta, so he has to stay in a lodge in ISBT, and at midnight he was arrested, my lord. So he is a student. He came from Borpeta. He has known any nexus from Aizawl, Mizoram, or any bus staff. Contraband was solely recovered from the bus, my lord. Not his possession, not from the hotel, my lord. And he is 4 months behind the bar, 4 months, 9 days as on today. He is a regular student, my lord. So kindly one opportunity may given for build up his career, my lord.
He was arrested on 12/4/2025.
My lord.
Anyway. So, for your own interest, I think the FSL report would be helpful. I mean,
Suspected.
similar. Your good name, please?
M.U. Ahmed, lord.
M.U. Ahmed. Also, it is submitted that the accused is a student and he's not at all connected with the alleged recovery of commercial quantity of contraband in the nature of narcotic drugs. Ganza, is it Ganza?
No, suspected
Heroin.
455.
Heroin. First of DP Goswami, learned additional PP, submits that though case diary has been received, but FSL is awaited. CD be written, which suggests date?
29.
29. Okay.
Short date.
You want it earlier?
My lord.
Well, actually, it's all back to 1/9. It's motion day. 1/9.
My
One day.
Offline. Hello.
21.
मैटर में पासवर्ड फॉर टाइम बिंग oblige
45. Supplementary 45.
Fine. Case diary has come? Not come?
Not come. Nobody coming.
45.
Just a minute. Oh. Sorry. You are appearing as amicus? None appears. Should I take it up after some time or? We have, are we ready to, conduct the hearing? Case diary?
Case diary not available also. We have not received the
Oh,
case
case diary is not come. And this is an investigation stage case, probably.
diary. Investigation is good.
Yeah. Yes, it is.
425.
No, it's not.
425.
Hmm.
Can be.
None appears today on call. The case diary has not been received. Respondent number 2 is represented by learned amicus curiae, M.K. Brown. Good stop. Issue requisition, fresh requisition for the case diary. Case diary of Tamulpur PS case number 89 of 2020. Fix on any date you want to suggest?
As per your lordship.
One nine
46,
May I please, your lordship?
EC Act.
Lordship.
Mhm.
Regular bail application, 48 days behind the matter.
Okay.
So far as sections as allegations are concerned, it is not less than 7 years. And your lordship, if your lordship go through the ground of arrest,
Can we see, okay, your first ground of arrest, or should we see the Azhar or ground? Okay, as you wish.
from the ground of arrest, it will be clear
Okay.
that what is the
Page number.
page number, operating person 25, ground of arrest.
Okay.
May I read, my lord?
Yeah.
Ground of arrest, the below noted arrested public servants, 2 persons were arrested, my lord. One is already granted bail by the learned court below. The below named arrested person, public servant Prasanta Kumar Gogoi is the FIR named accused person. There was demand of bribe by the accused Prasanta Kumar Gogoi from the informant as per the verification report. The accused Prasanta Kumar Gogoi and Vishwajit Gogoi was apprehended in a trap laid by the officials of Directorate of Vigilance and Anti-Corruption Assam, Guwahati. Immediately after Vishwajit Gogoi accepted 20,000 as a part of the demand bribe 40,000 from the complainant on behalf of and in capacity with Prasanta Kumar Gogoi, the present petitioner. The bribe money was recovered from the left hand grip of accused Prasanta Kumar Gogoi in presence of the independent witness. The handwash of both the hands of accused person Prasanta Kumar Gogoi and Vishwajit Gogoi were collected, scaled, and seized accordingly, with apparently shows positive result of the presence of phenolphthalein. This is the case, madam. And
Trap case. They
lordship-
were employees of which department?
lordship, excise. He
Excise.
is present, working as deputy superintendent of excise, office of the district commissioner, excise branch, Saraido district. Okay,
Arrested on the same day, obviously,
Lord,
4th July.
lordship. And their voice samples has already been recorded and COA case has already been granted bail. We have filed the, annexed the order by way of an additional affidavit. Thereby, my bail petition are rejected and others was allowed. And so far as the custodial period is concerned, madam, 48 days behind bar.
Just, we see the order. Okay, fine.
One additional is published on before lordship, my lord. That he is 57 years old, my lord. In his service career, there's no allegation against him and
Earlier,
no charges against him, no allegation. My lord. It's not misunderstood.
case diary,
We have received that.
case diary.
Let's first take a look to page number 18, madam. This is the vernacular FI, madam.
Wine shop shifting,
I'm just.
wine shop shifting, right? In the context of a shifting of wine shop.
Already, my lord, that my lord, he has get the approval from the my lord, from excise, office of the excise department, my lord, Guwahati, my lord. Then he submitted, my lord, he went to submit before the my lord, deputy superintendent, my lord, from deputy office of the deputy superintendent, my lord, that is the my lord petitioner is concerned, my lord. Then my lord, উক্ত কাৰ্যালয়ৰ বিষয়ে deputy superintendent প্ৰশান্ত গগৈ যোৱা ইমান তাৰিখে তেওঁৰ কাৰ্যালয়ত গৈ মোৰ অৰ্ডাৰ কপিটো বিচৰাত তেওঁ 40,000 টকা উৎকোচ দাবী কৰে। Thereafter, my lord, he lodged a formal complaint, my lord, before the anti-corruption trial, my lord.
ACB.
Yes, my lord. Thereafter, my lord, the tape was organized, my lord, and he was caught red-handed, my lord, along with the witness person, my lord. So there are sufficient materials, my lord, because this is a theft case, my lord.
What is the progress of investigation?
Progress of investigation, my lord, it is
Final form not yet submitted.
final form not yet submitted, my lord, but sufficiently progress, my lord. It's not about that.
Kindly, can I have a look?
Yes, my lord.
You may. You can have a seat. Transcripts of conversations are also there.
My lord.
Telephone transcripts are also there.
Transcript also there, my lord, the report also received, my lord. Last 2 pages, my lord. Last second page. It is also matches, my lord. There both of the investigating officer, my lord, there is a report, man, mentioning about the first sampling recording, man.
The 483 bail application filed by accused Prashanta Gogoi is seeking regular bail in connection with ACB police PS case number 41 of 2025 under section 7 within bracket small a of the Prevention of Corruption Act 1988. I wrote the section 61 2A BNSS. Okay. This is the gist of the allegation is that the accused herein, who is the excise official, demanded a bribe from the bribe of rupees 40,000 from the informant who was seeking shifting of his wine shop And upon the complaint being lodged, a trap was laid and he was apprehended, taking the bribe, alleged bribe. Full stop. Bora, no, P. Bora, Learned Counsel, submits that the investigating authority must have got sufficient time for conducting the investigation. Full stop. That comma. The petitioner accused is aged 57 years, and that he has no criminal antecedents. Full stop. That comma. In his service career, no such incident, alleged incident, had ever taken place. Heard learned additional PP, R.J. Bora, who submits the case that before the court. It is submitted by the learned prosecution that though investigation has progressed, but the same has revealed materials lending support to the allegations about the offense of bribery. I perused transcripts of the telephone conversations stated to be between the informant and the accused. Which prima facie are implicating in nature. The learned additional PP has also drawn my attention to the note of the IO regarding the voice sample report from the FSL. Considering the serious nature of the allegations, within bracket corruption and financial crime, and the fact that investigation is still in progress, the instant bail petition stands rejected at this stage. Return back the case there. Bail petition stands disposed of.
Obliged.
I'll take a 5-minute break.
Daily bail hearing at number 23.
Please, Lordship. We have to receive the case diary.
Not received.
Not received. Lordship, this is service is also awaited, I think.
Service is awaited.
Almost 3 months. My case has been pending. And a report was called from the.
Have you received any information regarding service lordship? So I'll take instruction again with him. He is not received yet.
Case diary is not yet received. The learned additional PP undertakes to take instructions regarding the service as well. Fixed on.
Online.
Maybe a little bit shorter, Lordship.
You want short?
Yes, Lordship. Actually, I have been waiting for this 2.5 months. This
Anticipatory bail.
Nothing has been updated, Lordship.
Anticipatory.
Not CD, no report, no service.
Anticipatory bail always has urgency, no doubt about that.
Yes, Lordship.
So, but subject to constraints of all of us, you know.
Then next week we have already fixed lots of cases.
I know that is the thing. Everybody
Lordship,
is of speed, but
a report was
what to
called for.
do?
A report was called for regarding the genuineness and authenticity of the birth certificate, Lord. That has also not come.
And these are the matters where it is difficult to consider interim
of age, Lord. The victim, Lord.
Anyway, so can it be on 29th or overloaded? 29.
Lordship is for CD and a report of the
Yes,
birth certificate and
case diary.
service.
It will be for bail hearing only. So
Yes.
hopefully in the meantime, CD will come, I think, but report, I think, report we need to.
Obliged.
24. In this case, my lord, case diary received probably, but service is not
Okay.
completed as that is complete, my lord. But
Oh, that's a, no problem, then. Case, amicus,
yes, amicus limit.
It is submitted that case diary has been received and respondent number 2 slash informant has also been duly noticed. Full stop. Since none has appeared, therefore, Miss Manisha Karen Brown, learned counsel, is hereby appointed as learned amicus curiae for our respond number 2. They can registry will furnish her a copy and then we can take up at the earliest. 27th.
20. 25.
May I please also? Service is complete, my lord. What matters pertaining, my lord, the informant along with his family members, my lord, kidnapped the victim girl, my lord. My lord, admittedly, my lord, all the sections is not attracted. Your lordship, kindly see page number 25 of this honorable court, my lord.
Yes.
My lord. 25, my lord. Para 5 and 6, your lord.
Arising out of the same case?
Same case, my lord.
Another accused.
And my parents and my brothers and sisters-in-law, my lord, this honorable court granted bail. Only that time, my lord, the petitioner not before your lordship. Subsequently, he filed this case. I admitted the victim girl, my lord.
And lordship, kindly will look very recently, this petitioner before your lordship, page 19, NHR 2, he has been noticed to appear before the investigating officer, my lord, on 4/8/2025 at 11 AM. And as per my instruction, my lord, having, my lord, this interim protection.
Actually, when I notice, as I understand, when a notice is given and the person appears, he cannot be arrested within up to 7 years, right?
My lord,
That is the original 41A.
my lord.
But if the notice is violated, then he can be,
Violation, but pursuant to 41A notice, my lord, he has not appeared, my lord.
He has not appeared.
He approached his honorable court, he took an interim protection, my lord, then he appeared, my lord. And after his appearance, my lord, he has not cooperated.
There is an inbuilt protection in that 41A, as I understand. Anyway, let us just give me one minute. I'll want to read it myself again. Of course, it's a none is name, but indicates a scam.
Yes. Now, my lord, we have that case there, my lord, lordship may say this is a voluminous case there, my lord.
This is the case there.
Yes, my lord. So, my lord, I have prepared the, my lord, both, my lord, what are the materials that have been, my lord, they had found during investigation, my lord. So I'll take to page it.
Okay, you have written it down.
Yes. my lord.
Okay.
My lord, lordship may kindly pay, my lord, that will be, my lord, helpful for your lordship.
Thank you for your homework. Certainly it will help. I'll see, go through it. No, these kind of investigation are will be voluminous.
There are, my lord, several accused persons, my lord. Investigation is still going on, my lord, and they are not yet been apprehended, my lord.
Who's the petitioner here? Abdul Halim
My lord, ordinary, my lord, village.
Abdul Halim
Person.
or Bhuyan. Yeah.
My lord, as per my lord, at that time, my lord, I was there, my lord, as a lawyer, my lord, and I heard, my lord, how this kind of scam, my lord, I dealt with some cases at that stage, my lord, 2020-21. My lord, even, my lord, I don't know, but my name, even I may be older person, my lord, fake, my lord, school record is made up in my name, my lord, some, my lord, bank account, ATM card, everything is procured. And it is, my
Actually,
lord,
these are the core ingredient of these kind of activities is identity theft.
yes, my
You
lord.
know, your identity is stolen actually,
Exactly, my lord. And it is not possible, my lord, without hand of
or
the
manufactured fake
yes,
identity.
officials, my lord. And officials knowing all these things, my lord, they passed, my lord, all the names, my lord. And when, my lord, this money was given to the respective fake account, my lord, and they jump to the ATM, my lord, and take up all this money. My lord. Basically, this is, my lord, from the officials, my lord, mainly involved. Because it's a monetary matter, my lord, and my lord, several, my lord, levels of, my lord, this passing of this list.
Just a minute. You sit down. Let me read it peacefully. Okay.
My lord, at this stage, my lord, I oppose it, my lord. Interim, my lord, bail may be rejected.
No, it's a final only, final order only.
Yes, my lord.
Final. We'll dispose it of. Mommy, I got order to first two paragraphs. See. The petitioner was granted interim protection on 4/8/2025, pursuant to which he appeared before the IO. His statement has been recorded. The case diary has been received, which reveals extensive investigation. The learned additional PP RJ Bora objects to the grant of bail. Detailed report prepared by the IO regarding the findings of investigation vis-a-vis the present the present petitioner has been submitted before this court, and I have carefully gone through the same. As per the investigation officer, then The investigation prima facie found several incriminating materials linking the present petitioner to the alleged offences which are in the nature of scam of scholarships pertaining to minority students. Such materials against the petitioner are also stated to be in the nature of false representation and manipulation. On the basis of the materials found, he was summoned through a notice under 41A, but he did not appear. And subsequently appeared after being granted interim bail by this court.
Before time, my lord, here, before the date of appearance, he approached the resolution of the court.
The IOS projected the necessity of custodial interrogation in the investigation. The investigation per se lends support to the allegations, including against the petitioner, though initially he is not named in the Azahar. The alleged offences are in the nature of financial crimes on an organized scale, with highly detrimental effect on society. It would be unjustified to put roadblocks in the investigation on part of the court, and the investigating authority should be given laxity to conduct the full investigation within the ambit of law and following all the safeguards. In such view of the matter, the bail petition stands rejected. Return back the case there.
Not problem.
Right.
Proceed for it.
37.
My lord, my instruction is that, my lord, he appeared on, my lord, 8/8. Before my lord, investigating officer, my lord. Lord, at present he is cooperating, my lord. Otherwise, my lord, his implication is there, my lord. Because my lord, JCB, my lord. And it is used in the destruction of forest, my lord. That is there. But my lord, he is now cooperating. He appeared, my lord.
CD has been received.
My lord, she did not receive, my lord, instruction received on phone, my lord. That is here.
I'll go learned counsel for the petitioner. 482 bail application by petitioner so and so Nangrang Tongke in connection with Vishwanath offense number so and so on the 51 of the Wildlife Protection Act. He was granted interim bail on 4/8/2025. The learned special public prosecutor Forest Department, upon instruction, submits that pursuant to grant of interim, the petitioner appeared and has been cooperating in the investigation, which however is still in progress. The given facts and circumstances, the interim bail granted by 4/8/25 is hereby made absolute subject to the condition that he will continue rendering cooperation to the investigation and shall not hamper or tamper with evidence. The bail petition stands as posted.
Condition is necessary, my lord, because he is from another state, my lord.
Huh?
The condition, my lord, lordship mentioned.
Yes,
that
it's
is
two
necessary.
conditions. Any other condition you want to suggest?
My lord.
He will not abscond.
Right.
He will not abscond.
28.
Lordship, this matter may be adjourned for
Yep.
today as my senior is not well.
Receive not,
Another day
not
maybe.
received the case diary also.
Case diary is also not received. Case diary not yet received. Learned petitioner counsel also seeks an adjournment. Issue fresh a reminder for the case diary fixed on when
2/9.
2/9
Lordship on 30. On
30 is a
29
close date.
holiday.
Holiday.
It's a holiday.
28, Lordship.
It's a
It's a NDPS case, intermediate quantity.
immediate quantity. Let it be on 1st September.
First of-
Right? 1/9.
30. For why, yes, please. Pursuant to the interim order, I have appeared. Basically, Lordship, FIR is page 14. It's a violation of a rent agreement and a compromise deed. And the generator set has already been returned and recovered. Only the amount is left, Lordship. Otherwise, 35 free notice was.
Yes, sir.
Fourteen is the may I read?
No, I'll go. Nice. Primarily a transactional dispute,
Yes, commercial is also.
but the informant thought that he was cheated, so he has filed this.
Lordship, I have returned the DG set, only the amounts have left, Lordship. I will slowly return, Lordship. Basically of civil nature based on an agreement and a compromise deed.
But here the case is that, my lord, the accused petitioner, my lord, took a, my lord, that is a set on rent, my lord. Then thereafter, my lord, in the meanwhile, he takes some money from another person, from Thupdora, my lord. That, my lord, with a promise to give him, that there is a sale, one sale. But that he take a rent from another person, sold to another person, my lord. Then, my lord, neither this man is getting the rent, neither he has been, my lord, given that the
Machine.
state, my lord. That is the case, my lord. When, my lord, that is once, my lord, that is they informed the police. We are in Fraudulent police station. That time that person appeared, and he said that I will return it back and compromise the was made. Thereafter, my lord, till then, when, my lord, he didn't, my lord, return the same, then this FIR was lodged. Accordingly, police investigated the matter. Police find that person, that is whose name is, my lord, in the FIR, my lord, from Thupdora, a person's name is reflected in the FIR. That person just said that, yes, I bought that is the set from this person. And later he came to know, when police came, yes, this is the set, and he bought me, and I have come to know that the original owner is someone else, man. So now he is also a witness, my lord. Other persons are there. Otherwise, he appeared, my lord. This is the case. And in the meantime, police, my lord, sees that, my lord, DG set, my lord, and, my lord, the Zimma petition was moved.
Return to the owner.
Original owner, my lord.
Original.
That is the informant, my lord. He, my lord, filed, and
Informant.
after the bone, my lord, was given. Otherwise, his involvement is there. He taken, my lord, that is
Yes,
there
yes.
from rent from one
No,
person,
that's
then
true.
sold to another person, my lord.
Right.
Yes, my lord.
That if the
All,
that
my
is
lord,
true, then
sufficient
the
materials are there, my lord,
conduct
that is
is
the
bad.
witnesses also implicating.
Mm.
Even in his statement, my lord, though, my lord, accused statement is not, my lord, that is, we are not, my lord,
Mm.
going through that, my lord, that he also, my lord, there he stated. Otherwise, he appeared, my lord, within the period of time.
I am appearing, I will cooperate, Lordship. I have already the disease said is recovered.
Mm.
Basically, I will return the money also.
My lord, may peruse the, my
Lord-
lord, the
Lordship would see
statement
the-
also, my lord.
FIR.
I've seen
It is enclosed only the compromise deed and rental agreement, therefore, whole thing is a commercial dispute, therefore. If I am paying for it. The interim order.
heard so and gave also learned additional people. Last order to second paragraph releasing. It is submitted by the learned counsel, petitioner counsel, that pursuant to grant of interim bail on 7/8, the accused petitioner has appeared before the IO and is cooperating with the investigation. Full stop. Case diary has been received. It is submitted that though the investigation has found materials against the present petitioner, but in the meantime, the shed, DG said,
My lord.
Generator.
DG generator has been given in Jima to the original owner. The dispute arose out of the said DG said, which the informant had supposedly given to, correct me if I'm wrong, if there's any error in narration, given to the accused to run, but he did not return the machine. And also an outstanding amount of rupees 3,36,000 has been had accumulated. This submitted by the petitioner counsel that out of the accumulated amount also, the accused is repaying the same in parts and will clear the amount. In the circumstances, the interim bail granted by the interim clearance bail 7/8/2025 is hereby made absent, subject to the condition that we shall cooperate with the remaining investigation, not hamper or tamper with evidence, and may also endeavor to engage with the informant and work out a settlement with regard to their with regard to the original dispute giving rise to this proceeding. Return back is the bail petition stands disposed of.
Number 32, 33, 34.
Connected. Orders are in. Just a minute, before you start, just cross checking something. Admission of asana. Process.
We have received the case diary, madam.
It orders. Orders.
Oh.
3 bail connected bail petitions.
Yes, sir.
Which one should I take up first?
Before my
Yakub Ali.
Yakub Ali.
Yes. And 35 also similar, my lord.
33, 34 similar.
There are three, 32, 33, 34.
My lord, arising out of the same FIR, my lord, and on the three, my lord, three petitioner, my lord, they are FIR name equals person.
My lord, can't come to the FIR.
Hmm.
Yes. Lecture 1. Yes, lordship, what, my lord? To the officer so accused Nazrul Ali, Yakub Ali, and Hatim Ali. The complaint humble submission is that my father was serving as the head teacher of the Mirza Tarpara High School. My father was a simple, modest, and amiable natured person. I have absolutely no knowledge of any monetary transaction or exchange of money in consideration of any interest between my father and the above mentioned accused persons. However, for about 6 months, one of the above named accused came to our house and demanded payment of interest money and abused my father with very bad and obscene words, causing us to fear for our lives. When my father went to school at Kalida Kuchi Chowk, they detained him and attempted to physically assault him with the intention of disgracing him. As a result, his self-respect was harmed and his attendance at school became irregular. Furthermore, the said persons on various occasions abused my mother in Hindi language along with my father, and as a result which my father became mentally disturbed and is presently suffering from Alzheimer's disease. During times when my father was not at home, they came and abused me and my mother in absence of the in obscene language and then left on 6/7/2025. This date may be noted, my lord, about 10:39 p.m. 6/7/2029. They came to our house and not finding my father, once again abused me and my mother in the same manner as before. However, they behaved obscenely towards me and then left. Consequently, my father, being unable to tolerate such continuous harassment of our family by them, and also being unable to bear the burden of their demanded interest, became mentally distressed and on 3/8/2025, after about a month, was compelled to commit suicide. In my opinion, the above mentioned accused persons are responsible for my father's death. I also believe that one of them, by threatening my father to possession of ATM card. Therefore, I request you to kindly investigate the matter so. The allegation, my lord, that on 6/7/2025, on the month of, in the month of July 6th, they came and left threatening and also took the ATM card. But again, in some paragraph, the informant says that father was absent and mother and dad. So ATM card must be with the father. The total made out case. And after 1 month, he commits suicide or dies. Whatever what he said, there's no suicide note, nothing. And in this paragraph on the FIR, the Lord will come to second paragraph. However, for about 6 months, one of the above named mentioned accused, who was that? Who was one of them? No name is given, either Nazrul or Yakub or Hatim, one of the. In fact, whatever manner the related facts is manner, I have explained in paragraph 6 manner. Income. Paragraph 4 manner of the petitioner. The petitioner submits the relation between the petitioner and the petitioner was purely commercial in nature. The deceased had purchased certain hardware items because the Yakub Ali has hardware shop manner in the village. Items from the petitioner on credit, which is common business practice. The petitioner supplied said goods in good faith
on the promise of future payment. It is the petitioner's legitimate right to seek recovery of the outstanding amount which remained unpaid for a considerable period. The petitioner was merely seeking to recover the lawful dues owed to him and never demand any unlawful interest also. There is no question of any transaction. There is nothing in the FIR also. Instead, it is interest. And the FIR was written, perhaps written by a lawyer, Marit, the language it is used. So, Mother, simply he the dues in the shop, Mother. And in fact, on the entire village, Mother, this person had the reputation of taking money from different persons, Mother. And the different people would demand money from him. He was, Mother, he was a head teacher, but he would borrow money. I don't know why, either to run the family or to gamble or what. But he had number of persons who he owed money. So, Mother, this is, I don't know, in the trial or Somali, I think it is not a contestable case. It will be 50 excess only. Anyway, that is a long time to come. So, Mother, here, simply to demand my own money. If I go and demand, pay the money. There are, my lord, two sections are available. And 396 available, 340, 57 available, and 296 and 308 not available.
108 is non-billable, right?
Yes,
Rest are billable.
yes.
Rest are billable. 106 is 108 is 306 earlier.
Abetment, yes. 108 abetment of suicide, non-available. There is no incident of abetment or anything. Nothing there. Simply demand of money. The informant is what it pays. So they will cooperate with the investigation matter, and they are local people, the businessmen. They would not flee a restaurant. The lawsuit can consider the grant of serious bail and let them be given any condition that they would cooperate and they would not tamper with any evidence if there is any evidence at all. But I doubt whether there is any evidence or any witness also.
Informant, Mr. Talukdar, you appear? Informant, for an informant.
My lord, we have received the case diary, my lord. The investigation is, my lord, going on, my lord. It is very in a nutshell stage, my lord. Now, my lord, as far as the materials are concerned, my lord, admittedly, my lord, he borrowed some money from the accused person, my lord.
And he was pressurized.
Yes, he was pressurized, my lord. They came to his house, my lord. They were
Pressurized.
even in the house, my lord, demanding money, my lord. Even, my lord, when he goes to, he's a school teacher, my lord.
Very
When
aggressive
he
pressure.
goes to school, my lord, they followed them to the school also, my lord. Now, my lord, later on, my lord, before committed suicide, my lord, he stopped going to the school also, my lord. And there are witnesses, my lord, who has implicated all the three persons, my lord.
We
And
can
they
be
came to their house, my lord, demanding money. The abatement part is very much there, my lord. And at this stage, my lord, I oppose this bail application of all the three accused persons, my lord. One accused person has been granted interim by this honorable court, my lord. But other two accused persons, my lord, they were not granted interim, my lord. So, my lord, my humble submission, my lord,
I
at
see.
this stage, my lord, all the accused persons, my lord, clearance bail may be rejected, my lord. Because there are sufficient materials, my lord, collected by the IO, my lord, and still, my lord, there this ATM card, my lord, and phone record, my lord, they are yet to be investigated, my lord. Phone has been seized, my lord, but ATM card has not yet been recovered and seized, my lord.
It's an anticipatory bail. Right?
Anticipated bail,
Yes. Any condition also
So there are sufficient materials, my lord, so I strongly object, my lord, at this stage.
Yes, there is certainly contains some materials, my lord, written by police. My lord, earlier, may I say one thing, my lord? This case, calling of case diary started in the, sometimes in 90s, my lord. Earlier, even in murder cases, the honorable judge would go to the FIR and they would understand whether there is a case at all and grant bail or NC bail. In one of the cases, my lord, my senior was SKC and my Dr. might have heard him, very senior lawyer. I was his junior. We were moving an NC bail application in a murder case. Justice Lahiri, K.M. Lahiri was the legal judge.
He was just going to the FIR. This is the murder case, one of the PP said, well, let the police report come. I think what is the matter? What the honorable judge says, do you think that High Court judge should be guided by a note written by a ASI? Are you not intelligent enough to see the FIR and decide what is the case about? And bail was granted. That was the situation. But the calling of the FIR, CD.
No, it's not a question of an ASI guiding the High Court judge.
No.
You know, every authority has his own powers.
Yes.
And he is entitled to exercise his jurisdiction in his own. And another authority can take the assistance of that findings of another authority. I see that.
No, that was this.
See that.
Since 94.
Every authority's status is important because work is different, right?
Anyway, decide.
There can be different opinions.
Yes.
Please.
My humble submission, I am appearing on behalf of the informed also. The allegation is that he took money, that is admitted crime. That part he has admitted also. So far he has been pressurized to return the money, that too with interest. And because of their chatting, he stopped going to the school also. Thereafter he committed suicide.
He became depressed.
That's right. And ultimately his ATM has also been taken away. That part has still now, it has not been recovered. I don't know. Whether it is recovered. That is the allegation made in the FIR. In the statement also they have stated.
Actually, what has happened is that, this maybe we need a new provision of law. But this 306, certain a person conducts certain activities. He may, generally I'm saying, generally, because this has become relevant in many 306 cases now. A person does certain activities which may be improper, whatever, and those activities have a bearing on another person taking his own life. But they in many situations it has been found that they do not come within the ambit of the definition of abetment, which is aid, instigation, conspiracy. So this is the thing, actually. In many situations, it will be very interesting to see the conviction rate of 306 offenses. But people are aggrieved by a suicide claim. So, because of the family members, in relationships and all that. There's a judgment, a recent judgment penned by our Honorable Ujjwal Bhiya sir. But I think Shiva Kumar. So they've gone, in this thing. But that's for trial.
That is for
So it is very difficult actually to say,
stage.
what would constitute abetment. Suppose somebody continuously tortures someone and then he commits suicide, but will that be abetment? Abetment means something, assisting in the suicide.
Yes.
Instigating him to commit suicide or conspiring to commit suicide.
Of such nature,
No, there is, in one situation, your degree of proof will be less when you have the presumption under 113 in married woman. Otherwise, it is quite a challenge. Anyway,
Here after 1 month.
it's quite a challenge. But obviously, the family will be very aggrieved, no doubt. So, can I have a look at the CD?
Item number 33, may I submit?
Yes, you can complete your submissions, connected submissions.
Item number 33, I'm appearing. Now, Lordship is correct, whether the two non-bailable sections, that is extortion and abetment of suicide.
Extortion is also there.
Extortion cannot be there, Lordship knows, because it is our own money. And Lordship, I kindly take up item number 33, my daughter, the petitioner's daughter was suffering from blood cancer, she Lordship knows how expensive the treatment is. Admittedly, he took money. And when we were asking his money, not only me, there were lots of villagers, he took money. He did not return. When my daughter was suffering from leukemia, she died, and how expensive the treatment is. Asking my own money, then he committed suicide. It cannot be on the extortion. That is my humble submission for your Lordship. And that for a death certificate, I have annexed, and I have categorically stated that he, the cause of death, page 16 is her cause of death, he died of leukemia. So,
page?
Item number 33,
Hatim Ali.
Oh, sorry.
Hatim Ali,
Yes, yes.
my daughter was under treatment since long, my lord.
For the illness.
Yes, my lord. My phase 15 is a death certificate, and phase 16, my lord, is the cause of death, my lord. So, my lord, asking my own money, and my lord, it cannot be a pressure upon from someone, my lord. Admittedly, my lord, there was some transaction, not only me, but from many persons. But unfortunately, when the person he died, my lord, that is a very unfortunate. But we are helped. But my daughter died, my lord. She was under treatment since long, my lord, in my lord, leukemia. Then, my lord, and moreover, extortion, my lord, lordship knows only there cannot be an extortion, my lord. This is my humble submission, my lord. They will appear, my lord. They have asked their own money. They have not, my lord, asked, my lord, it is not a board. They are not borrowing from him, or they are pressurizing that you give us some sanda or like that, my lord.
In respect of my lord Hatim Ali, my lord, there another FIR, my lord, lost by one Jahanara Begum, my lord, which was registered as, my lord,
It's similar allegations.
PS case number, my lord, that is Hazur PS case number, my lord, 20/2024, my lord, under 306 ICC, my lord. That person also, my lord, consumed, my lord, due to pressure.
Are they money lenders? No.
Maybe, my lord, that will be in the investigation.
High interest money lenders also. Anyway. Yeah, after the break, we'll complete your submission. Immediately after the break, I'll dictate, or inside only I'll dictate.
I will submit at 2, madam. My submission.
Submit. At 2. Okay.
Even now I can.
Yeah, you can.
Yes, madam. My petitioner is my lord Nazrul Islam, my lord, question number 1 in the FIR, my lord. My lord, very unfortunate, my lord, that person has committed suicide, my lord. But my lord, kindly see, my lord, he treated me as his son, my lord. My lord, that the deceased, my lord, treated me as his son, my lord. He has 3 daughters, my lord, not son, my lord. He treated me as his son, my lord. During his, my lord, need, my lord, he took 5 lakhs from me, my lord. I borrowed it from one of my friends, 3.5 lakhs, my lord, and give it to him, my lord, 1.5 years ago, my lord. My lord, he's supposed to return it, my lord. My lord, he give each and every date, but not return, my lord. Before the date of suicide, my lord, he was supposed to return the money, my lord, and he asked me to come, my lord, to Guwahati with him, my lord, because he's one of his brother, my lord, stayed here at Guwahati, my lord. So he's supposed to return on that day, my lord. But that's why, my lord, I was repeatedly calling him, my lord, before the date of his suicide, my lord. I was repeatedly calling him, my lord. I have sent some messages also, my lord, whether he will go with me or not, my lord. But he is not responded, my lord. In the morning also, my lord, in which day he was committed suicide, my lord. Morning also I have called, my lord, several times, my lord, but he has not received my call, my lord. I have annexed the charts also, my lord, in the annexer B, my lord. That is clearly reflect, no threatening, nothing, my lord. My lord, he took money from most of the persons of that locality, my lord. Because of that, my lord, possibly he has committed suicide, my lord. And the allegation of, my lord, that the accused person went to the, my lord, his house, that is 1 month back, my incident, my lord. There is no affair on that issue, my lord, on this regard, my lord. 1 month ago. That's why suicide note is also not there, my lord. And it is not that they're continuously, my lord, threatening him, my lord. Nothing there, my lord. My chart is there, my lord, with my bail application, my lord. Your lordship may kindly see, my lord, whether any part of threatening is there or not, my lord. Nothing, my lord.
So these are the WhatsApp messages, my lord. Only he has annexed, my lord.
Yes.
We are supporting him, my lord.
They will verify, my lord, whether it is because this is mobile seized by the, my lord, IO, my lord. Whether they have verified that or not, my lord. Because this
investigation is going on, my lord.
IO, my lord. So, my lord, if the investigation is going on, my lord, then, my lord, your lordship may extend our interim. And, my lord, let them, my lord, inquiry. Who kept the ATM card? With whom this ATM card are, my lord? And what is the bank transaction? Who has withdrawn the money from the ATM card? The CCTV footage will be there, my lord. It will be clear, my lord. We have been extended the interim order, my protection, my lord. And other 2 accused persons are not on interim. They have granted interim protection, my lord. We will cooperate, my lord. Their statement will be recorded. And in the meantime, they will collect the postmortem report also, my lord.
His statement,
My statement,
recorded.
On 18, my lord, I was protected, but on 19,
Your
I
statement
get
is
the copy, my lord.
His statement is
Yesterday I have, my lord.
My lord.
Yesterday I have appeared, my lord. I have
Yesterday
the,
only he appeared, my lord.
Not yet come.
not yet come, my lord. Possibly not in the
It is
case
not
diary.
in the case there.
So, my lord, up to date case diary may be called for, my lord. And with the postmortem.
Up to date case diary along with the postmortem report will be required.
Yes, my lord.
In the meantime, they may be protected.
Because
Postmortem report will be
my lord, because the question is of ATM card, my lord. Two ATM
Hanging-
card is there.
hanging. That
It's
may
a
not.
case of hanging, my lord.
That may not
So,
be.
my lord,
Yes.
yes, although
Postmortem not
report is
required.
That may not
It is
be
not disputed,
so
my
much
lord.
contentious.
Yes, my lord. It is not disputed. But
Okay.
my lord,
Only-
who has, my lord, withdrawn the money? That ATM card, my lord, that is in the FIR, my lord. That needs to be verified, my lord. Who has withdrawn the money? The investigation is initial stage, my lord. We have been protected, my lord. We will again appear, my lord, if required, my lord.
At
Let the
this stage-
updated case diary come, my lord.
At this stage, my lord, lordship will only, my lord.
Without any, my lord,
only
material, my lord,
lordship
why he
to
objected, I
confirm,
don't know, my lord.
Whether, my lord, the abatement part is there or not.
Yes.
And from the statement of the, my lord, witnesses, my lord. If there are clear, my lord, the clear evidence that, my lord, but there are, the accused person, my lord, they harass,
Just a minute.
accused person harass the victim, my lord,
Harass.
for which he is committed.
Harass.
Even, my lord, stop going to school, my lord.
Harassed.
Lordship, that
All are, my lord, the three accused are relatives of the is my lord. But
Neighbor.
he is
Neighbor.
perhaps
Neighbor.
being demanded money by many of the villagers who will borrow money.
Lordship, in item 34, with all respect to my senior submission, I just want to
Add one thing.
add one thing, that in the first paragraph itself of the this complaint, that vitiates the entire affair, lordship. If your lordship takes up page 11 of page 34, the first paragraph, the complainant's humble submission is that my father was serving as head teacher at Mirza Sipra school. My father was a simple, modest and amiable natured person. I have absolutely no knowledge of any monetary transaction. She had no knowledge. Even at the time of affair, this statement is made. So how this amendment comes for demanding money or anything? Where is the note, lordship? This is absolutely on presumption. On the basis of presumption, law cannot run on the basis of presumption. This is just presumption of the, and all interested person has made the statement, and that is how this case diary has been developed. The actual fact is that no, in absence of any suicide note, why the man might have died for any, he was suffering.
All
maybe
suicide
suffering-
cases do not necessarily have note,
Yes.
as you would agree.
Yes.
Or every time suicide note is not available.
Available. Even then, but for substantiating, for connecting in the offense, those ingredients, the vital ingredients are absent, lordship. So, lordship, now benefit of doubt, we are ready to appear. Local people, lordship, we have on bona fide belief, we have given our money to him on bona fide belief. Now he has died. Now we are not after money. Let it go. At least, lordship, for our we should not be detained, lordship. We should not be harassed, lordship, for helping someone. That is my humble prayer. Let us cooperate. We are local resident. We'll abide by any of the condition, lordship may please to frame. We'll cooperate. Even require, we'll appear every day, lordship, before the police station for the purpose of cooperating the
Not
investigation.
necessary. Should someone
Lordship.
appear every day?
Love it.
Police is very busy. Anyway, so I'll dictate after.
Lordship will produce the case diary, my lord.
Keeping the school also, telling us some allegation against him. 4 months he has not been paid salary by him. That's the letter.
That's a separate.
Lordship,
Anything?
Lordship, as regards item number 41, I am seeking for an adjournment on behalf of my senior.
41. Okay. Hearing matter. Another day, you want to?
Yes, Your Lordship.
41 adjourn. Date to be fixed? Should we fix a date? 2018 matter.
Yes, Your Lordship.
Any, you can suggest a date.
Lordship, next Thursday,
Next Thursday,
28th, Lordship.
fixed on 20th.
Obliged.
Granted interim anticipatory bail on 18/8/2025. Pursuant to which is stated to have appeared before the IO as directed
On 20, my lord.
As directed on 20.
20.
And as submitted by the learned counsel, Mr. Mullah. However, the case diary though received is not reflective of the same as yet, as submitted by learned additional PP, RJ Burra, full stop. RJ Burra, comma, who also objects to separately separate stuff. The learned petitioner counsel submits that the offences of abating the suicide of the victim cannot be attributed to the petitioners, even though the death of the victim, death of the person is very unfortunate. On the other hand, learned additional PP RJ Bora submits that case diary has been received and investigation is still in progress. It is submitted that apart from the accused petitioner being named in the Adhar, the witnesses have also stated about harassment meted out to the victim by the accused persons. All the materials revealed right from the Azahar are indicative of monetary transaction and the petitioners exerting tremendous pressure on the victim and on the family regarding the said, resulting in the tragedy of his suicidal death. In BNSS 2023, the offense, next paragraph, the offense of attempt to suicide has been rechristened as section 108 IPC BNS within bracket corresponding to section 306 IPC. However, the ingredients remain the same. It criminalizes the act of abating the suicide of a person. It is well settled by various decisions that to make out an offense under the said penal provision, two basic ingredients are necessary. Firstly, that the death of the victim was a suicidal death. And secondly, the accused abated the said suicide. No separate definition of abatement is provided in section 108 BNS /306 IPC, and the ingredients of abatement for this provision is also adopted from the provisions of section 106 IPC corresponding to what is the new section BNS. The three basic ingredients of abatement are: number one, abatement by aid or abatement by instigation or abatement by way of conspiracy. Next paragraph. Coming back to the incident proceeding, which is a bail petition. The needless to say that the aspect of abatement would be a subject matter of the trial in the case in case charge sheet has been charge sheet is submitted. What requires to be decided at this stage is whether the materials would justify detention of the accused persons and oblique or their custodial examination. Let's do. It is contended by on behalf of the petitioner that the elements of extortion cannot come as they were seeking return of their own money. There is some force in the said contention from the prima facie materials. If the allegations and the prima facie materials about the petitioners harassing the victim and their entire family for return of the money are true, then undoubtedly the same is a bad conduct which could also attract some penal offenses. However, from the materials on records so far, it remains to be seen as to whether it can be said that the accused petitioners played an active role in aiding or instigating or conspiring in the suicidal death of the victim. Last sentence ki likh lo. Okay. In the given facts and circumstances, and considering and in the backdrop of the above discussion, I am of the considered view that the petitioners can be granted bail subject to suitable conditions to ensure that the remaining investigation is not prejudiced. Therefore, the interim bail granted to the petitioner herein is is hereby made absolute subject to the condition that he shall cooperate with remaining investigation, shall not intimidate or harass the informant side and their family, shall not hamper or tamper with evidence. Violation would lead to so and so. Baki kata fresh ke dibo laga. Baki the other two fresh ke interim, there is no interim. In the event of arrest, 20,000, 17. Before parting, it may be mentioned herein that anything expressed here regarding the matter is only for the purpose of the bail and should not be taken as any opinion on merits of the main matter if it proceeds to trial. Return the case there, bail petition stand disposed. I've recorded the objection, Borwa. I've recorded the objection. Is objects to the grant of bail.
Supplementary 48.
Itu das. এই মতে অন হৈ থাকিব লাগে নে? মানে চকুত লাগে অকণ। বন্ধ কৰি দিলে।
Yes.
আপোনাক লাগে?
48 also in this case, charge supplication.
Charge. Okay.
Protection was given to me on 31/7/25, my lord. Thereafter, I have appeared before the investigation.
In this case also, the respondent appeared.
Again, the investigation state for which respondent is not notice was served to them.
So
Yes, sir, as far as
Respondent appeared, my lord, on the last occasion.
someone had appeared, but did not appear. Subsequently did not appear. No problem. Notice is necessary.
But notice necessary on the day of hearing, my lord, when the protection was given to me, they were hard.
Oh, no, you cannot, we cannot force anyone to come to the court. So our duty is only to notice.
Yes.
First two paragraphs, last order. TCR has been received?
No, it was investigation stage, charge sheet submitted.
Okay.
It's neither in time notice.
Okay, and TCR was called for in the last order actually, earlier.
Yes.
So, the learned additional DP Goswami submits that
TCR not received it.
charge sheet has been, submits that upon completion of investigation, charge sheet has been submitted in this case. The petitioner counsel submits that pursuant to grant of interim, he has appeared.
He has appeared.
Appeared before the investigating officer and cooperated with the same investigation. The given facts and circumstances, the interim bail granted to the petitioner by the order dated 31/7, hereby made absolute, subject to the conditions that cooperate with remaining investigation, not harass or intimidate the informant or victim, not hamper or tamper with evidence.
I'm deeply obliged, man.
Supposed to.
Finding item 9.
9, 10, 12 hours. 9, 10.
I'm sorry, Manu, I was not there, Manu.
No, it's okay.
It's a anticipatory bail, Manu. Your lordship will find the FIR at page 8.
There are some two connected matters also I was told. Should we take up together? Okay, now I'll hear you first.
Fine.
We can take it up. That's what I was told.
Page 8 is the FIR, Manu. It's a
Yeah.
case under section 108, Manu.
108.
108. May I read, Manu?
306 again. No. Okay.
Well, respectfully submission is that both the above mentioned accused are involved in interest business. My father, namely so-and-so, borrowed money in interest from the accused few months ago. After return of the capital amount, the accused number 1, he mentally tortured and threatened my father for the interest amount of 10,000. Well, rest is with regard to petitioner accused number 2. So accused number 1 is before your lordship.
Similar.
Similar between other one.
High interest, lending.
Well, here, in fact, my
And
lordship,
people also fall into these traps.
yes, well, actually, only one submission, my lord. I have narrated my fact, my lord, page 3, my lord, paragraph 6, my lord. Page 3, paragraph 6. May I read, my lord? That the petitioner accused number 1 begs to state that he is a businessman who deals in business of mobile phone.
Where is it? Page number 2 of your petition?
Page 3.
3 of your petition.
Para 6, last paragraph.
Oh,
The petitioner accused number 1 begs to state
got
that
it.
he is a businessman who deals in business of mobile phone and he has a shop at Town under so and so, my lord. Next paragraph, my lord, next page, my lord. The petitioner accused begs to state the fact of the case is that the deceased purchased a mobile phone on installment basis from the petitioner shop. Whereas the deceased failed to repay the installment on time, the arrear was due for the last 1.5 years. Therefore, the petitioner asks the deceased to return back the arrear.
This is the case.
This is the case, my lord. And page 16, my lord, the petitioner father expired, my lord. My lord, on 20th of August, my lord, the Sardha ceremony is there, my lord. Page 17, my lord.
Yesterday it was there. No interim protection?
Yes, please, my lord.
No, no. Was there any interim protection?
Yes, my lord. Well, this is a motion matter, man.
Oh,
Motion, I was not there. I'm sorry. Dear.
no. Why should I be sorry? You have to do so many other matters in
I
other
was
courts.
stuck up in one post.
Yeah, of course.
I'm paying for interim, my lord.
So Lordship is well aware of the earlier cases also, Lordship is also the case diary also in the other. I prefer this is case diary. That's it.
Four 82 bail application seeking bail for petitioner Debojit Das, Puchu Das, alias in connection with Ding PS case number 182 of 25 under 108 BNS. The allegation in the Azahar dated 19/7/2025 lost by the son of the deceased is that his father borrowed money from the accused, and with regard to return of the same, but especially the interest, he began to be tortured by the accused, and eventually on 16/7/2025, his father committed suicide. Petitioner counsel has drawn my attention to para 6
And 7.
and 7 of his petition made on affidavit, in which it is narrated that the deceased had purchased a mobile phone on installment from his shop and failed to repay the installment, and arrears was pending. And the accused petitioner had only asked the deceased to repay the same. Yes. On the basis of these limited materials, it is difficult to express any prima facie opinion about whether elements of abatement of suicide are attracted, which requires specific ingredients like aid or instigation or conspiracy in the suicide of the victim. Third, learned additional DP Goswami call for the case diary. However, in the interim, in the event of arrest of the petitioner in connection with the case, 25,000 with one security, subject to the condition that he shall cooperate with investigation here before IO, not hamper or temporary. In the circumstances, at this stage, before finally adjudicating the bail, it may be fair to allow the petitioner to appear before the IO and record his version of the events. Right?
I'm obliged. Deeply obliged.
The usual trap, people actually the root is economic. People have financial difficulties. They need money. The normal banking channels are not open to them. So many formalities. So they fall in the hands of money lenders. They give the money, but the interest is very high. So unable to pay, this kind of the same tragic script. Same tragic script.
So 11-9 Lordship.
Same,
Case diary.
11-9.
11.
Okay, interim is there.
14.
Same matter.
No, my lord, this is a matter, my lord. My lord, before going, my lordship, may come to page 3, my lord. Paragraph 3, my lord.
Page 3.
Page 3, paragraph 3, my lord. May I read, my lord?
Just a minute. Can we see the Aadhaar?
That's why, my lord. That's why this paragraph is important, my lord. That the petitioner begs to state that on 17/8/25, a copy of the FIR sent on his mobile phone by the informant, which is received by the Jalukbari police station, and also on the same day in the evening, the police personnel from the Jalukbari police called the petitioner number 1 over telephone to make for visiting the police station. Thereof, the petitioner number 1 inquiry about the FIR through a friend, and the police personnel informed that the case is yet to be registered. The informant has sent the FIR, my lord, which I have annexed, my lord, page 11, my lord.
This one?
This one, my 11, my lord. It's regarding, my lord, promise to marry, my lord. So whether this case is registered or not, my lord.
We don't know.
We don't know, my lord. That report.
So report takes any cases registered against the petitioner.
Used in
All right. But this, yeah, you are aware of the complaint?
Yes, but she has sent me over WhatsApp, my.
She has sent.
She has
The
sent.
informant has sent. So they are
My.
earlier acquaintance.
My. Speak them and all them. Whether it has been registered or not.
482 with apprehension of arrest with regard to FIR/complaint dated 17/8/2025 at the Jalukbari police station. As a copy of the same was electronically sent to the petitioner by the informant. As they had earlier acquaintance. I can write that one. Full stop. It is, however, stated that the petitioner is not sure about the registration of any case, and therefore before this court. Third, NJ Doctor call for a report from Jalukbari police station as to whether any case has been registered on the basis of information dated 17/8/2025 lodged against
Petitioners.
the petitioners by Noor Nehan Jasmine from Barpeta district. And if so, the particulars of the said case. Right?
On 27/8.
27 fixed on so and so date for report.
1916.
তিনটা যে থাকা আপনি ক'লে একে বুলি ভাবিছো একে নহয় তিনটা যে থাকা আপুনি ক'লে তিনটা একেলগে একে ধৰণৰ তিনটা সেইটো নহয় আৰু যে থাকা আপুনি ক'লে
Another matter is fixed on 26th, Lordship. So this matter should be fixed on that date, 26/6. We have informed.
This is trial is going on, right?
Yes.
In Bongaigaon. Are you agreeable to that? We can fix it on 26th. DP Goswami, learned additional submits that another bail petition arising out of the same FIR is fixed for bail hearing on right?
Lordship.
On 26/8/2025. Your good name?
Adeka.
Ardeka, learned counsel for the petitioner, fairly submits that she is agreeable to the same. For this matter to be fixed along with the said bill application.
Along with BA number 632/25.
List on 26 along with BA number
632/25.
Yes, Lordship.
Item number 21, along with protection list 1.
I am appearing item number 21, my lord. My lord, if your lordship have a look, my lord, at page 15, my lord. Because the FIR is not, my lord, rightly translated, my lord.
Page 15.
Page 15, my lord. Brief of the case. Mary.
Yeah.
On 8/7/25, one complainant, Mohammed Anis Ali, son of so and so, my lord, lost FIR at the police station stating that on September 21, two FIR named person, Babul Ali, and number 2 is Mustafizul, district so and so, came to his house and stated that they will credit some government scheme money to his account, and thus took his PAN card and Aadhaar card and collected the OTP from the complainant. Recently, the complainant learned that one loan amount of rupees 4,000 was shown against him. Now he has paid rupees 9,000 to close the loan. The complainant stated that the accused person fraudulently collected the ID proof documents of the complainant and some other person of his village and misappropriated an amount of rupees 250,000 in the name of providing government scheme money to the poor uneducated people. So from the complainant, my lord, only 4,000 was. I am not on the merit of the case, my lord. Today is, my lord, 44 days. My lord.
It's a bail application.
Bail application. Today is 44 days. My lord. Cheating for 7 years.
Yes, they approached several persons for providing him some government schemes and taking loan in collecting a Aadhaar card, PAN card, and later on they have got the information that some loan was taken against them, lordship, and default of payment they have been informed. Several witnesses were examined, lordship. They stated that yes, this petitioner that was taken loan from various institutions, but 2,000, 4,000, total 7 persons were cited by this petition.
Only on the length of detention. I'm not on merit of the case.
Respective of the amount, the idea of someone taking a loan in your name without your knowing is very scary.
It's scary. How can it be possible?
Think of it. You have to repay.
This is happening.
47 days, but investigation is progressed.
Progressing, but for a statement of the victim, lots of persons were cited. They are yet to be examined.
I think let the
only few of
maybe better for the investigation to be completed. I think. Straight the nature of the allegations. This is also same. This.
Yeah, he is appearing.
Yes,
You can take it up together and hear it.
I think he, my petitioner name is Babul Ali. He is Mustafizul.
You can make common submissions with
Yes,
him
ma'am.
also. Yes,
both of them were implicated by
both
the
are implicated.
Both are implicated.
Investigation be completed. 483 bail application. Khetri police station, 61 of 25. The present accused was arrested on 9/7/2025. The allegation is about taking identity and other documents from persons and fraudulently taking loans in their names and misappropriating the amount. Full stop. The informant is stated that a loan was taken in his name of rupees 4,000 and he had to close the same by paying rupees 9,000. Stop. Learned counsel N.J. Datta fairly submits that he's seeking bail mainly on the length of detention. D.P. Goswami learned additional on the basis of the received ED, received case diary, submit that investigation has revealed, has implicated the accused person in activities of cheating people in this modus operandi. Considering the nature of the alleged illegal activities and the fact that investigation is not yet completed, the bail petition stands rejected at this stage. Return back the case the similar order. This will be implications.
I'm okay.
In the given facts and circumstances, this would not be a appropriate case for grant of anticipatory bail at this stage. Accordingly, stands rejected. Return back to civil. I got it at this stage, you know, both cases at this stage.
I'm okay.
Next one is item 2.
Kuntu.
Production is item number 2.
30 kuntus.
I don't know if you use the disposal.
A2. DG set. DG set matter. That DG set matter, right? No, I think you had submitted. That machine, the connected matter. Some. Forgot. Take it up. Ekelege will pass the order in that. Kune likhisil na. Olop likhi lok tithal. Follow it up. 482 bill application for seeking Hussein Zabrut connection with Fulton Bazaar case number 460 of 24. I don't know. Dot. Can you give me the number, connected number, bail application number?
Connected cases, my lord, item number 30, my lord, dispose of matter today.
189.
1891, Rakhi.
1891.
Dispose of. Next.
So, my lord, here in this matter, my lord,
He's another accused, no? This matter.
my lord. My lord,
I've dictated only a part of it.
my lord.
He is also one of the persons regarding that DG set and the conflict about that return of money.
My lord, that is the Jebin George, my lord.
Huh?
Is it Jebin George, my lord? Because my lord, production is not available with us. That's the problem.
Amount is being paid, repaid by installments. That matter, I think.
Yes, my lord, it is the IA, my lord, connected to that, my lord.
IA, it's such.
Yes, my lord, this for orders, my lord, this item number 2 is IA, my lord, connected with this item.
It's the order matter. Order has come as a production list. Wait. Let me see the prayer. Oh, so he's seeking a correction. He's seeking a correction of the bill. I get it. Learned judge is not available. He's in Aizol.
Oh, yes,
Sharma.
otherwise, my lord, the matter is
I can
disposed of.
dispose of it. I can correct it.
Right.
I can.
Because my lord, now whether my lord, after my lord, that is the making it absolute, whether my lord, that correction is required.
Not required, but
Actually, because it's the absolute matter.
It has to be together. And prior to that, actually. Otherwise, it has no meaning, actually. Infructuous in a way.
Yes, my lord.
I will keep it with that main, like a silent. It has actually become infructuous. The main, it was sign board and pass an order.
A2 connected to 3. It was only effective.
Order item 49.
Me, please, Your Lordship.
Oh, it
This
was- it was
application has
already-
been filed for modification of a bail condition, my lord. In order dated 19/9/2023. The passing BA number 3209/2023, Lordship. Wherein, Lordship, the petitioners were required to deposit their passport in original before the learned special judge CBI, Lordship. Lordship,
Your Lordship, I need some time to give a reply. to
In
this
some
question.
international flight risk.
Lordship, I think the petitioners are required to travel abroad frequently because, Lordship, the sons and daughters, they study abroad. The wife, Lordship, she undergoes treatment in Singapore. Also, they have businesses abroad, my lord.
Where is the order? Can you show me the order?
Lordship, order, Lordship, is at page 42, Lordship. Effective portion will be at page 50, my lord. Effective portion, paragraph 14, Lordship, clause 5, condition number 5, my lord. Page 50. The condition number 5, my lord.
Nice, I get it. Okay, it's okay, no problem. But you need some
I need some time to
instruction.
give the appropriate instruction from the branch. And this is conducted by Delhi branch, SU2.
Mhm.
So a bit time.
PC Act, right?
Lordship.
PC Act.
PC. PC.
You can take instructions.
Yes, Your Lordship, I need some time. That is. Now, we have to deal with the parawise reply also.
Yeah.
Before passing any order, I need to give some reply to.
It was specific, I'm just asking, you know, the CBI prayed for such a condition or it was imposed by the court?
Because some
Not
FT order is also there, proceeding is not going ahead.
ahead,
In this case, the proceeding is also stayed, Your Lordship,
I see. Because of,
on the behest of the petitioner, accused.
Lordship.
why he's filed some
They
criminal
have
petition?
the petition.
Criminal petition.
Yes, Your Lordship.
Lordship, at page 52, my lord.
And there are other cases also there. There are number of cases, charge sheet. There are not a single charge sheet.
I
There are
see.
multiple charge sheet.
You take instruction.
So I need instruction before passing any order, Your Lordship. I need
No problem.
some time to give parawise reply and the present status of the case.
IA criminal 879 of 25. Yeah. Miss
P. Borua.
Borwa. Learned Council heard the application has arisen out of a prayer seeking modification of condition guide para 14(5), so Roman 5. The order dated 19/9/2023, passed by this court, granting bail to the two petitioners are there,
Two petitioners.
to the two petitioners herein in connection with CBI case number RC, page 43, page 43. M. Kumari, learned retainer counsel CBI, submits that she needs some time to take instructions, so also file parawise comments. Prayer is allowed. Fixed on so and so date for, you want to file a written reply?
Written reply. Minimum 2 weeks time is required.
No problem. The prayer is allowed. List after 2 weeks or 3 weeks, 2 weeks. 2 weeks in the orders column. It will come forward to soon.
Much of like this, deeply of that. Lordship, I'm sorry, Lordship, if a date can be fixed, my lord.
You want me?
Can this be?
559?
5-9, Lordship.
Is it okay? 5-9 or 8-9?
Let it be on 8-9.
8-9, okay.
Deeply obliged, my lord.
Admission item 15.
This is a quashing petition, Lordship, quashing of a DB proceeding initiated by the wife, Lordship. In ex parte interim order was granted by the court, Lordship, and against that, this proceeding, this quashing petition and
Quashing of the interim order only.
interim and the entire proceeding.
Entire proceeding.
Entire proceeding. My case is that, Lordship, the allegations which were leveled by the wife against the
Complete the trial and pass judgment within 30 days from the date of order. Then High Court did not interfere. Then went to Supreme Court. High Court impugned order after considering the contention of the parties, give the following findings while dismissing the criminal petition. Then, my lord, paragraph 9 can be. The order rejecting the appellants quashing the petition is assailed before this court. Although question there is here is this order, challenge has also been laid to the direction to conduct de novo investigation to CBI. Learned counsel appearing on behalf of the appellant submits. This is Article 20. Then this submission. Then paragraph 10 can we see these are the submission regarding section 300 CRPC and 386B CRPC that I have argued on the last occasion also. The stand of the respondent CBI is reflected from the record is under. It was stated that acquittal or discharge of the appellant was not based on merit of the case. The acquittal order was passed by the High Court does not have the effect of final acquittal. As the appellant proceeding did not result a determination of affirming the conviction or acquittal on merit. This was submission of the CBI. Then ultimately, Supreme Court, my lord, in next page. Paragraph 11. We have heard the learned counsel for the parties. The issue which raised for consideration before this court are whether the High Court was justified in directing de novo investigation and retrial of the same offence on the same set of facts after acquitting the accused by giving him the benefit of doubt. Here, in the present case, benefit of doubt, and in our case, on the ground of sanction, after full-fledged trial.
Technical acquittal. Technical acquittal.
Technical acquittal.
In a way.
Here, in this case, on benefit of doubt. In other words, when considering an appeal against conviction under section so-and-so, is the High Court empowered to direct re-investigation? If yes, then could such direction be given while acquitting the accused in the very same order? Lordship, got it? In the very same order, acquittal can be de novo inquiry. Whether in the attending facts and circumstances, the de novo investigation violate the principle of double jeopardy and appellant's right under Article 20 of the Constitution of India and Section 300 of CRPC. In the present case, the High Court acquitted the appellant and directed to transfer the documents and relevant material to conduct the de novo investigation before CBI on the same facts of the same offence and to proceed against the appellant in accordance with law by exercising power under section 386 of CRPC. The power of the appellate court as described 386, power of the appellate court. Then, paragraph 20, section 386 B of CRPC empowers power of the appellate court, which inter alia includes the power to order the appellant to be retried or committed for trial in case of appeal or conviction.
The court is of several decisions deal with power of the appellate court to direct retrial. The constitution bench so and so is it is quoted constitution based judgment, then bribery case also quoted.
Anyway, so
And ultimately court held that this power is not lie with the trial court or with the investigating authority.
anyway,
And ultimately this allowed this case for reinvestigation by the CBI. And in my case also, my lord, kindly see, they have not, after acquittal, they have not preferred any appeal or revision before this high court.
that appeal has had attained finality according to you.
That acquittal has attained finality.
Let madam take the instructions.
Yeah.
Okay, so old matter will fix it up. No, we'll fix it. But since this is just a preliminary introduction, it may not be kept as part third. What do you say?
It may be kept in part of.
It may not be because I've been introduced to this. I've been introduced. That's why I stopped you, because if you go deeper, again, it will be wasted if it comes before another
Well,
bench.
There is a
Because only
technical
problem-
glitch with regard to the prosecution sanction.
My lord,
And there is a number of
only problem
Supreme
is,
Court judgment is also there.
It's a interesting-
Subsequently, it will come.
It's an interesting case, actually.
only problem is this case, my lord. Suppose my revision is dismissed today, then it will go for trial. Here in this case, the informant died, 2 accused died. The judge who has delivered judgment, he also died. The advocate who appeared, he also died. Only I and the accused is
And the
remain.
revision judge is alive. Present revision.
Present.
They may,
Only nothing. And other witnesses,
time is like
most
that
of the
only.
witnesses also died.
Time is like that only. Everything goes.
So
Anyway,
that is
so
why I am praying for early disposal, because my client is also at the age of 78 years.
okay, that's fair enough. So the
It is come on 8 itself. One matter.
okay, Ghosh Learned Council appearing for the
And 9.
award is also heard it over a last paragraph. The learned retainer council submits that she may be given some time to take instructions. And what are the you want to file a reply? Not
Not necessary, it is a.
may not be
revision. It
essential also.
May not be essential, but provision.
Some
may be-
instructions
some
and
instructions.
file a
If
written
reply.
file a written reply if necessary. So he's right actually. Let's people have their old people, they want to whatever it is,
That I do, I
they
agree.
want to
But only glitch is prosecution.
die with
sanction,
a
yes.
outcome whatever it is.
Yes.
So when should I, how much time would you
9th. 9th of September.
in the hearing list?
Not here, not. It's a hearing. list.
It's a 12 matter, so in any case it will come up.
So on 9th, it's a 9th.
9. I only wish we could have a system of taking, hearing the matters in the morning when we are fresh.
Yes. In that point of.
In the morning,
yes,
when
can
we are
give
fresh.
Time also.
Then your lordship may.
No, I mean, that's not the system. I'm just saying.
No, it may be.
My-
taken up as a first item.
My desire is in my mind.
It may be
In
taken up as a
priority,
first
not
item.
exactly first, but in priority.
But no,
Yeah.
we have other matters now.
Other matters are also
So
there.
hearing, so that is the thing. Anyway, so it will come on 9 and automatically it will be in the upper part of the list because
So
it's a
if-
12 matter.
If motion and orders is not there, then it will come.
Yes, no, hearing also, hearing part, it will come in the top.
In the hearing list, it will.
You
come
know
in the
that
list.
more than me. Okay, 9 for hearing, for hearing. That is judgment for you.
Much of.
Much of it.
36.
Part third name, no. আৰু কেইটা hearing হ'ব পাৰে? এইটো মাৰিব লাগিব। চবটো নহয়।
My lord, record is with me, my lord.
No problem. Vijita, you have,
Yes, Lordship. This is a old matter of 2012.
not amicus,
No.
private counsel. This is the sentence.
Sentence, imprisonment for 6 months and fine of rupees 1,000 under section 498A, which has been upheld by the appellate court.
Is here. We're going, okay.
Yes,
Keep it,
but I'm just.
keep it, no problem.
Jahar, this is incident of, in fact, the alleged incident is of 18. Alleged incident is in the year 2012, and the incident is that on 23/5/2004. That is also one of the ground, and the alleged incident was of 23/5/2004, and the complaint was lodged on 4/1/2005. So it's almost 8-9 months later.
Just a minute.
Some explanation was given that they were trying to settle it, but mentioning about the village headman, but that person was also not examined to establish that actually because of that reason there was a delay of almost such a inordinate delay in lodging the
6 months.
infant. No, it's 20, almost 8 months. Yes, 8 months, almost 8 months. Jahar, at page 9.
I'll read, don't rush. Well, you can keep the record, Bishop, if you want.
Well, I have
I'll come-
already gone through my,
Okay.
and I have flag mark my
Okay.
relevant parts.
After management. You have to see the depositions, right? 4 witnesses.
Four witnesses. So those witnesses are in vernacular. Lordship may
Let me see if I can negotiate. I'll take your help.
PW1 is the informant and PW2 is the father of the informant. PW3 is a neighbor and PW4 is the IO.
Victims,
Victim is PW1.
just a minute. Okay, you want to read something? PW3 is a labor.
Neighbor.
Neighbor. Sorry.
Neighbor. And PW4 is the IO. PW1, who evidences has been discussed at page 16 of the judgment of the petition lordship. That is the judgment. So,
Trial court judgment.
yes.
You can read it, this thing. You want to read? Let us read PW3 first, then we'll read
Yes,
the,
Lord.
because this is bit short.
PW3 is short, Bengal, it's in Bengali.
Okay, Bengali Kasar, no?
PW3 is that.
I will have some problem with PW1 and 2, the handwriting, but
Yes.
PW3 I can manage.
Yes, PW3 and 4 is readable.
I can, no, it may be for me, you may be able to read it. It's a hearsay, PW3.
Yes, Lordship. And also regarding that 1.5 years, but according to the PW1 also she had stayed 2 years. So that 1.5 years, that is also not very clear. And he also stated that there was never any other incident, only that is the one incident which possibly don't attract 498A.
Can you read this the woman's
That vernacular is also not with me, but I have read it from the judgment in fact, because the vernacular is also not.
No, I will not
clear.
trouble you, but if it may be a problem for you also. Can you read?
Smile.
You can.
Smile.
Expert, huh?
Not expert, my lord, but I can try. Dada. Record.
Yeah, I'll follow. You can read. I'll note. I've just flipped through the appellate court reasoning. So once I want to hear that, then I will cross check with the appellate, this trial court judge, whether this, what kind of error, if any, is there, or whether it is correct. Long time has elapsed in any case.
Let's start from PW1. Then
1 year.
Yes, sir.
Three I have read already.
Yes.
He's more of a hearsay. He has said that Bolechin, that he was reported about Marpit.
No. on oath মাইলট বিদ্যাসাগর বাসুর সাথে 2002 সালে আমার বিয়া হয়। হিন্দু শাস্ত্র মতে বিবাহ হয়। বিবাহর পরে আমি আসামির বাড়িতে গেলাম, স্বামী স্ত্রী হিসাবে বসবাস করি। এটা ছেলের জন্মর পরে এই ছেলের বয়স প্রায় 2 বছর। বিবাহের সময় আমার বাবা গাই গরু আর সোনার অলংকার, ফার্নিচার, টিভি আর ব্যাটারি দিয়েছে। Then my lord further seek is reserved, and then my lord 1/12/2000, my lord, that is 5, my lord, and that is the first, my lord, that is the deposition was made on 28th of July 2005. আমার বাড়ির থাকার সময় পুত্র জন্ম হওয়ার পর 2 বছর বিবাদী আমার পর আমার এলিজিবল আমার হইতে 10,000 টাকা মতো ঠেলিয়ে থাকে। What I understand is 10,000 she is demanding, because it is in the, my lord, that is reflected in the, my lord, trial court's judgment and even in the appellate court judgment. উক্ত টাকা জানিও দিয়ার মাত্র বিবাহে আমার এদায় মারপিট করিয়া, not so much livable, তারপর 7 মাস আমি গর্ভ অবস্থায় আমার মারপিট করিয়া একটি, those parts are not so much legible, my lord, because
Earlier people used to write very badly, you know. Nowadays, of course, we have
the first part, see,
modern
very,
system.
my lord, that is legible, but my lord,
It should be legible. You
Yes.
don't have to have a very
Yes,
nice
my lord.
handwriting. If you have, it's good, but so that others can read, no, legible. Anyway, we have to manage.
দিন থাকার পর শারীরিক তাই গর্ভপাত হয়, তার নষ্ট হয়ে যায়, বিয়েতে হয়, হয়। My lord, what, my lord, that is, my lord, those not, my lord, so much legible, my lord, but from the, my
Kindly
lord,
see if you can read
so-
the cross examination.
Yes, my lord. ইহা সত্য নয় যে আমি পুলিশের নিকট বলি নাই যে বিবাদী 10,000 টাকা দাবি করিয়া মাঝে এক উক্ত টাকা, that's also, my lord, so much legible, my lord. Only what I understand is that the demand part, my lord, from suggestions are there, my lord, where she, my lord,
She said that she has stated the IO, but in IO's evidence, it is clear that that amount was not mentioned.
She stated about money, but not amount.
Not amount.
that is in the, my lord, IO statement, that is also.
I've read them.
Yes, ma'am. They are from Patama. This part, my lord, is difficult for me also.
Leave it, then we'll use from the judgment.
Yes, my lord.
I must have correctly interpreted them.
The legible part is that is the PW3 and PW4, man. That can be the independent witness and the IO. Other than that, my lord, in 313, my lord, that is the examination of the accused, my lord.
I'll read from the judgment, don't worry. If expert is not able to, then we don't come into the picture. Right. So, no, this will do. He has narrated, must have narrated correctly. Was he arrested during?
Yes, Lordship. 24 days he was there. Arrest memo shows he was arrested on 12/1/2005 and bail bond was of 4/2/2005.
Okay. Any explanation in the Azahar for the delay? No.
That explanation, one explanation was given that they before the village headman they went to amicably settle, but the block president was also not examined to prove that delay, Lordship. That is also one ground I have taken. And regarding the this miscarriage, etc., also there was no medical document to show that this was because of such, because already one child was there, and she had lived with the person for 2 years, and it's a very old case of 2004. Already 24 days behind the bar. Bar he had already out of 6 months. He had already 24 days. He had behind the bar, Lordship, and eyewitness was also not there. Although it is a village, Lordship, and the 2 persons are interested witness. The others she has neither in the Azahar not in before the IO. She had mentioned about any this amount of etc. And only one incident as per PW3. Had there been a continuous incident then also, Lordship?
Okay, do this problem. You sit down. Listen. Edward, পিছতে হ'ব আহাৰ গৈ talk কৰিম। Criminal division so and so. The revision petitioner Vidyasagar Pashi was married to one Sabita Pashi, but subsequently alleging demand of money and physical assault, he lodged a Azahar. It was a complaint case. No.
No, my lord, this is a GR case number.
She lodged the
FIR, my lord.
FIR, resulting in the registration of. I'll do it. Don't worry.
FIR dated, my lord, 11/1/2005, my lord. And this is
11/12/2005.
My lord, 11/1, my lord.
11/1/2005.
11/1.
Resulting in the registration of Silchar. Fill up the blanks here. Sometimes it is written nicely in the appellate courts. Really, guide come there on appellate courts. We'll find it. Don't worry.
Not 11/1, my lord, because my lord, here, my lord, in the appellant order is 4/1/2005.
is the
And
complaint.
Udarban PS case number 825, my lord.
Udarban PS case number 825 of 2005 under 498A IPC. Dash which after investigation resulted in a charge sheet against the accused and registration of GR number 98 of 2025.
My lord, that is a FIR is, my lord, that is the lodge on 4/1/2025 by the informant. But that was registered, my lord, from the exhibit of the FIR 11/1/2005.
I think it was sent to magistrate. Sorry, it was lodged before magistrate and sent to police. I think it appears so.
Yes, my lord. Yes, my lord. That's the reason, my lord. Yes, thereafter. জেলা কাছারে ফৌজদারি আদালত শিলচর
will এটু আমি modify করলাম
As
Uh,
the-
uh,
Madam, I
the
can this, the record of.
no problem. The petitioner as accused underwent trial before the court of the learned SDJMS Silchar. And he was convicted under section 498A by judgment dated 30/4/2012 and sentenced to undergo imprisonment of rigorous RI for 6 months
Alright, for 6 months.
and fine of rupees 1,000. ID SI for 2 months. Full stop. He preferred an appeal against the same. But even the same came to be dismissed in its entirety by judgment and order dated 18/9/2012 passed by the learned session judge Kasar in criminal appeal number 16 of 2012. Full stop. In this backdrop, the said convict appellant is before this court as a revision petitioner, seeking interference with his conviction and sentence. Heard, Vijita Sharma, learned counsel for the revision petition. Original TCR is available and relevant portions perused. The learned counsel submits that the Azahar has been lodged after 8 months. And though an attempt has been made to explain the same, but contends that it is not adequate. It is further submitted that in her police statement, she omitted to state about the demand of rupees 10,000 as deposed to her by in her evidence. Full stop. It is submitted that there are no documents regarding the testimony of the victim side regarding miscarriage, etc. Also heard learned additional PPK Boysa, who submits that in her testimony, she has stated about having faced cruelty and also monetary demands. The learned petitioner counsel has stated that both PW1 and 2 are interested witnesses, and PW3, though independent witness, is a hearsay witness. He's a hearsay witness. Next, upon perusing the depositions and the discussion of the evidence by the learned court below, I find that PW3 is a neighbor, and he has testified about being reported to by the informant. Informant is PW2.
One.
Informant is my lord. That is the
Victim is the informant.
Victim is the informant.
Yes, ma'am.
Father is 2.
Other is 2.
Reported to by the informant about the assault. However, one important aspect of his testimony is that he has reposed about hearing hue and cry on day of the incident. And one of in the day of the incident. Fine tune for it. Upon perusing the testimony of PW1, I find that she has testified about being assaulted and by her husband, assaulted by her husband, as a result of which she had to leave the background. You can come back. So many years. People, she'll feel good actually. There's some caring for this. But DLSA, it may not be easy to locate her.
Yes.
Because poor people, they move around sometimes. She may be there also. She may be there. Inquiry will be conducted. Note. Full stop. Therefore, consequently, upholding conviction under 498A, the petitioner is sentenced to undergo sentenced to the period already undergone during investigation and trial. Full stop. And the fine amount of rupees 1,000 ID SI for is kept is left untouched. Next paragraph. The learned DLSA secretary DLSA, it will be helpful for our child, and secretary DLSA Silchar may conduct the stipulated inquiry and award suitable victim compensation to the victim woman Sabita Pashi, resident of Digar Kasipur, PO and PS Udarban, District Kasar, in keeping with the provision under section 357, subsection 357 CRPC.
Now also CRPC or BNS?
This will be governed by earlier only. I don't know. Maybe. Yeah, you are right. It will be BNSS.
Yes.
Because whole proceeding is under
Yes. No,
CRPC.
but under it,
Oh,
then that is why.
what is the equivalent provision?
460, 463 or
Dot
something.
dot rakhibo. BNSS লিখি দিব লাগিব. Earlier 357
Yes,
এনেকে লিখি দিম.
Yes.
For this purpose, copy of this judgment and order, along with necessary documents, if any, shall be furnished to the learned secretary DLSA Silchar.
Madam, that is
For needful.
fine amount maybe increased, madam, or
Fine amount can be increased. 1,000. If we giving victim compensation, then it can. Should I increase the fine amount? These are a lot of change over like 5,000. 5,000. 5,000. The fine amount upon being realized shall be paid to the victim. Since the aforesaid amount may not constitute adequate compensation, therefore, in exercise of powers under so-and-so BNSS, 396, there's a subsection. The Secretary DLSA Silchar is directed to Miladi. The criminal revision stands dismissed subject to the modification of sentence and accordingly disposed of.
Obliged.
Return back TCR. I have to tell me.
Number 39 and 40.
Mhm.
May pray for date in 4th of September, matter the long pending case.
Yeah.
4th of September.
Actually, there's a meeting been called my personal. So, I
39
have to go because I have to sign some orders. That's why I'm getting up now. 39.
and 40, which method?
Hearing, right?
Yes.
39 and 40.
4th of.
All matters.
Whole method.
Okay. September,
4th of September.
4th of September,
Hearing date.
39, 40, on 4th of September.
Public.
Please, Your Lordship, item number 43, my lord. My lord, the date will be fixed, my lord.
Hmm?
The date may be fixed, my lord. Item number
47.
43.
43.
Going up for daily list, last item.
It is 23 matters. So let's, it's a review criminal petition.
Criminal petition question, my lord.
Washing, it has to be fixed in the
Second week of September, my lord.
last week. Yeah? Let
Last
it
week
be
of
on, let it be on 25th, 25/9. 25/9.
May I please, Your Lordship? Lordship, item number 41 is a long pending matter. Kindly fix a date, my lord. 41. John,
Just taken time.
my lord,
Taken time.
my consent was not taken actually. my lord.
You are for the,
I am for respondent number 2, my lord.
informant.
Informant.
She made a mention.
28.
28, but not so long for you.
Okay.
Kindly ask her. And she should have informed you actually. Courtesy. Okay.